Hello?
Hey, good morning, Judge. I got a couple, we ready. Oh, I need the prosecutor. Oh, I do have one where the prosecutor's on Zoom.
How do you use this?
Prosecutor. You ready?
Yeah.
Ready on Edward Lewis?
Yes.
Calling case number 2156691, the people of the state of Michigan versus Edward Lee Lewis. Defendant is charged with count 1, malicious destruction of a building, $1,000 or more, but less than $20,000. Habitual offender for notice. This matter is scheduled for a probable cause conference.
Appearances, please. Mr. Jadala,
Respect for Your Honor, Samer Jadala, P62186, appearing on behalf of Mr. Lewis, who I see he joins us today via Zoom.
all right, who's the prosecutor?
Good morning, Your Honor. Alexa Schneider for the people of the city of Detroit, P80322. The city is going to be taking this case over.
All right,
Your Honor, at this time, we'd respectfully request discovery and a probable a preliminary exam date, Judge.
Mr. Lewis, state your name, please. Mr. Lewis,
Yes, sir.
state your full name, please.
Edward Lee Lewis III.
Thank you.
Welcome,
All right,
Your
how
Honor.
many witnesses? Madam Prosecutor, how many witnesses?
We'll only have 3.
You need 3 witnesses for malicious destruction of property for an exam.
Probably just 2, Your Honor, but 3 was to be safe.
I couldn't hear you. Could you fade it out?
I'm sorry, Your Honor, my internet's going in and out. It'll likely be just 2.
Okay. September 16th at 10 o'clock.
September 16 at 10 a.m. is fine with me, Judge.
You as well, Your Honor.
Thank you. All right, anybody else?
Nothing further, Judge. Thank you.
Not from the
All right, thank you. Morning, Judge. Good morning. How you doing? Good.
Morning.
Hey, how you doing, Pete?
Elizabeth, I'm sorry, can I get your P number?
Of course, 84724.
Thank you.
Hello?
Okay. We ready on Wise, Robert Wise?
Ready.
Calling case number 2058564, the people of the state of Michigan versus Robert Wise. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. Evan Callanan, P30564, on behalf of Mr. Wise, who appears via Zoom and consents to this proceeding being conducted by Zoom. Judge, at this time, the defendant, having been advised of his right to a preliminary examination, would waive that exam.
People have any objection?
No objection, Your Honor.
Mr. Wise, please state your full name for the record.
You have to unmute yourself, Mr. Wise.
I'm sorry. Robert Lewis Wise.
All right. Mr. Wise, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Do you have any objection to the court signing your name to the waiver form?
No.
Mr. Callahan, do you have any objection to the court signing your name to the waiver form?
No, Your Honor.
All right, then the court will find that you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 4th, 2021, 9:00 a.m.
Thank you very much, Your Honor.
Thank you.
I'll call you, Mr. Wise.
All right, thank you. May 4th. I thought May 4th.
Ready on Adriana Canty. Calling case number 2156678, the people of the state of Michigan versus Adriana Canty. Defendant is charged with count 1, weapons, firearms, discharged and enter at a building. Count 2, weapons, firearms, discharged from a vehicle. Count 3, weapons carrying concealed. Count 4, count 5, weapons, felony, firearm. Count 6, malicious destruction of personal property less than $200. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. Mark Owada on behalf of the defendant. P number is 58029. It should be indicated on my screen.
Ms. Canty, can you state your name, please? Try that one more time. I couldn't hear you.
Andrina Canty.
Thank you. All right, counsel, what's your pleasure?
Your Honor, we just need an exam date.
All right. How many witnesses?
Your Honor, the people have been called 1 witness.
September 15th at 9:00. Is that a good date?
Yes, Your Honor, it is. If it suits the people, will that give sufficient time to locate and serve the witnesses, Madam Prosecutor?
Yes, it will. Thank you.
Thank you.
That's a month away, man.
We'll do our best.
All right. All right, just gotta make sure you're here at 9:00, because that's the only case scheduled at that time. I will call it at 9. All right?
Understood. Thank you, Your
All
Honor.
right, thank you. Bond continue.
Ready on Connor.
We're ready, Your Honor.
Blair? Is this yours?
Connor?
That's mine, APA Matt Franson.
Okay, there we go.
Oh, okay, I'm sorry. Calling case, calling case number 2157153, the people of the state of Michigan versus Shantez Connor Jr. Defendant is charged with count 1, count 2, count 3, count 4, count 5, assault with intent to murder, count 6, assault with intent to do great bodily harm less than murder or by strangulation, count 7, count 8, count 9, count 10, assault with intent to do great bodily harm less than murder or by strangulation, count 11, weapons carrying concealed, count 12, count 13, count 14, count 15, count 16, count 17, count 18, count 19, count 20, count 21, weapons felony firearm. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Matthew Franson on behalf of the people, P84002.
Good morning, Your Honor. For the record, Paul Talenda on behalf of Mr. Connor. I don't see Mr. Connor here yet, Your Honor. He's in Division 1.
All right, willing to waive his appearance for the purpose of this hearing?
Very good, Your Honor. Thank you. We'll just keep the exam date for next week, Your Honor.
Nope. I'm already booked up for next week. He's in Wayne County though, right?
He is. We were arraigned on the 12th, Your Honor.
Right. How many witnesses?
Probably just one, maybe two.
We can do the 27th at 2 o'clock. April 27th.
20, I'm sorry?
April 27th at 2 o'clock.
Very good. Thank you, Your Honor.
Thank you, Your Honor.
Mr. Franzen, we'll talk soon.
All right.
Thank you.
Yeah, it was up there, but I thought it was right. Ready on Akia Bailey?
Ready. Your Honor, if I may, before this case is called, Mr. Bailey has a case, and I was in Redford, and it was Utter Surgeon Publishing. And I understand this is a home invasion, so I don't have the discovery on that. I just wanted the court to know that.
All right, I'll make sure you get it.
This is the uttering and publishing.
Actually, this is the uttering publishing office.
Oh, very well. Okay.
Your Honor, sir, Mr. Taylor, the defendant will be seeing 17th today on video.
Oh, he's going there after this?
Well, he's got another case out of 36, Judge Williams, for traffic. But after that, we will put him live in Redford Township. But yes, he'll be seen today.
No problem. Okay.
All right, demanding preliminary exam, Mr. Taylor?
Yes, Your Honor.
Any witness?
I got a cold case.
Oh.
I paused because he was saying before he called the case.
Thank you for that email, Blair.
Calling,
Here.
we ready?
Yes.
Calling case number 2059267, the people of the state of Michigan versus Akia Bailey. Defendant is charged with count 1 and count 2, uttering and publishing habitual offender. Third notice, this matter is scheduled for a probable cause conference.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84734.
Good morning, Your Honor. Ed Taylor, here on behalf of Mr. Bailey. My P number is P57166. There you go.
All right. Mr. Bailey, state your name for the record, please.
Akaya Bailey.
Thank you. Mr. Taylor, what's your pleasure?
We request an exam, Your Honor.
People with 3 witnesses, Your Honor.
3 witnesses, 2 charges.
That's correct, Your Honor. We have obviously the endorser and then a bank representative from each bank because there were 2 different banks involved.
What, Mr. Taylor, why is your client locked up?
Your Honor, I haven't had the opportunity to speak with him, so I'm assuming it's because of these checks. But I do have.
It's personal bond on this case. Are you showing any other hold on?
Not to my knowledge, Your Honor. Yeah, we request a personal bond. That's fine.
Oh, you wouldn't know.
We wouldn't have it. Bailey, what else you got?
Your Honor, sir, this is Deputy Pravanchi. He has a felony case out of Redford in home invasion first degree. His bond is 10% of $100,000. And he also has 4 cases out of Detroit 36 traffic. Judge Williams.
All right, thank you. You can do this April 27th at 2:30.
Yes, sir. That should be just a minute, Your Honor. Yes, that should be fine, Your Honor. And could I have a DSU report too, Your Honor?
Sure. All right, thank you.
Thank you.
Your Honor, sir, will that be in person or via Zoom?
That'll be in person.
Yes, sir. Thank you. Have a nice day and be safe.
Do you know when Mr. Bailey's going to be in Redford?
He'll be in Redford about 9:30 this morning via Zoom.
Okay. All right. Thank you. All right. Hey, Mr. Bailey, I'll be in touch. All right.
Okay.
Ready on Christopher Smith? This is the one.
Oh, say that thing, man, folks.
Oh, he froze. Oh. Calling case number 2060127. The people of the state of Michigan versus Christopher Smith. Defendant is charged with count 1 In count two, controlled substance, delivery, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Second notice, habitual offender. Fourth notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Mr. Christopher Smith. Mr. Christopher Smith does not appear because he's in the Livingston County Jail under a federal detention.
Yeah, remember you adjourned it for PCC. Another PCC.
To locate where he was.
All right. You talked to Matthew about this case, because he was the one hunting them down.
I did not personally speak to Mr. Stoloff on this case.
I'm sorry, Your Honor, I did not hear you.
She said she didn't speak to Mr. Stoloff. Matthew Stoloff, the prosecutor trying to hunt down Mr. Smith's body.
I apologize, Your Honor. I was able to consult a note in this particular file. It's my understanding that at our last date, an adjournment was scheduled so that we could locate the defendant. We have since called the federal facility. We are still not able to locate this particular defendant. He may be in a facility that is in Lisbon, Ohio at this time, set to be released on May 23rd of this year.
Well, Your Honor, that's new information to me.
We have reached out to that particular facility requesting a Zoom appearance and have not heard back yet.
All right, well, what do you want?
Your Honor, since this defendant is set to be released in late May, we have an early first week of June appearance.
Probably not. How many witnesses you got?
We would intend to call 3 witnesses in this case.
September 16th at 10:30.
Whoa.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you.
Have a good day. I'll see you at 12:30.
All right. Yeah.
I know.
Any other attorney need to check in?
Pardon me, I'm sorry.
Good morning, counselor. You need to check in?
Well, I don't have a matter on the docket. I prearranged to have 2 matters in August rescheduled, but I don't see Mr. Stoloff, the prosecutor. I was told he'd be available with the files, and I apologize for adding to your grief this morning.
No, Mr. Stoloff is not with us today. Blair Moody is.
Okay, wait a second. Judge, I have no idea what files he's speaking about.
All right. You got the case numbers, counselor?
Yeah, but I hate to make you dig. Yes, I do. Would you like them?
Yes, please.
I apologize. I mean, I've got emails confirming that we were doing this. One is James Charles Brown, 20062-105-01.
Okay, what's the other one?
The other one is Aisha Lewis, 20062-73601.
Okay, so what are you trying to do, counselor?
I'm trying to move the exam dates for personal reasons.
They're set for August.
August.
8/12 on Brown. I do have them, counsel. Sorry, Steve.
Cool. Again, I apologize.
Aisha's 8/5.
Yeah, I got it.
Okay, you got
I
it?
did a ROA.
Okay, cool.
They're both scheduled in August, Judge. One is 8/12 and one is 8/05.
And I have no objection to advancing them.
Yeah. I got nowhere to advance them to.
I'm just, that part I can't control, I'm sorry.
You want me to call them, Judge?
Yeah, you go.
I don't have the files, I just got ROA.
Your Honor, if I may, with a wink and a nod, I don't think either one is gonna go. Based on my experience.
All right.
Calling case number 2062736, the people of the state of Michigan versus Aisha Lewis. That's IESHIA is the first name, last name LEWIS. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. This matter is here on an adjournment hearing.
Morning, Your Honor. Stephen Remsky, P30309, on behalf of Aisha Lewis. Judge, I do have regular contact with her, but today's date was arranged on short notice. I ask that you waive her presence.
Waive her appearance for purpose of this hearing.
Thank you kindly. I'm requesting an adjournment for reasons that I have conflicts in August, and I'm grateful for your patience.
People have no objection, Judge. We do have, it looks like one witness in this case. If you need that information.
One witness?
Oh.
One.
Just a heads up, it's my client's sister.
Right, I know. I saw that, Steve. Thanks.
All right, September 16th at 9:45.
Thank you.
Thank you kindly.
Excuse me.
Hold on, please. I'm in a hearing.
Yes, sir. I'm sorry.
Just do it in. All right.
Calling case number 2062105, the people of the state of Michigan versus James Brown, JAMES. First name, last name BROWN. The defendant is charged with count 1, harmful substance, device, person falsely exposed. Count 2, police officer assaulting, resisting, obstructing. Count 3, assault or assault and battery. This matter is here on adjournment hearing.
Good morning, Your Honor. Stephen Remsky, P30309, on behalf of James Charles Brown. Judge, I do have good communication with him. I would ask that you waive his presence for purposes of this hearing. I'm seeking to reschedule this matter for conflict reasons.
September 16th, 9:15.
That's fine, Your Honor.
Jefferson, the other one is 9:45, this one's 9:50.
Yeah.
Okay.
The first one we're waiving. This one we're about to waive. I'm also on. So the 9 o'clock is the waiving? Yes. I'm on hold for probate court. Waiting for probate court.
Take care, Steve.
Okay.
Your Honor, I very much appreciate you accommodating me, and I'm grateful to Mr. Moody. Thank you kindly.
Thank you, Steve. We'll see you.
Take care.
He was on Zoom.
All right, Mr. Ellis. Mr. Ellis,
Yes, sir.
we haven't done your case yet. We're waiting on your attorney to come on. All right, so just hold tight, please.
Yes, sir.
All right. Wayne County, who's that?
Yes, I have Mr. Connor.
Oh, yeah.
You said the Taz? What's the first name?
Just let him know that.
Shantez Connor.
Dantez
Are
Connor?
you already logged in?
Yeah, we just did that case. You, got a preliminary exam set for
For today in Archer?
April 27th at 2 p.m.
April 27th at 2 o'clock in the afternoon
Oh, okay. Yeah.
for in-person exam.
Okay, thank you, Your Honor.
Okay, thank you. Take care.
I can't. Oh, no. I don't keep them files. Oh, we need your initials. No, I sent stuff over to and I sent him a copy. Yeah. Yeah, he did. All right, this is a waiver, right?
Yes.
Yes, Ms. Kitty.
Ready on Brian Logan?
Yes.
Calling case number 20563030, the people of the state of Michigan versus Brian Logan. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, operating license suspended, revoked, denied. Count 3, operating while intoxicated. Count 4, failure to stop after collision. This matter is scheduled for examination.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. May it please this honorable court, Attorney Phyllis Gaten Robinson, P71733, on behalf of Mr. Brian Logan, who stands across my left shoulder. Mr. Logan, can you please state your name for the record?
Brian Logan.
Your Honor, today is the date and time set for a preliminary exam in this matter. Mr. Logan has been informed of his absolute right to a preliminary exam where it must be proven that probable cause exists that a crime was committed. Probable cause exists that he was a part of that crime and that he has been charged in the proper venue. He has made a conscious decision to waive that exam. Is that correct, Mr. Logan?
Yes, ma'am.
We have executed the form, Your Honor.
You have any objection?
No objection, Your Honor.
All right, Mr. Logan, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes.
Anybody promise you anything or threaten you in any way that you should waive your right to preliminary exam? You do so freely and voluntarily after having an opportunity to talk to your attorney about it. Yes. You sign the waiver of examination form?
Yes.
Say yes?
Yes, Your Honor.
All right. Court will find that you freely and voluntarily waive your right to preliminary exam matter found over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 4th, 2021, 9 o'clock a.m.
Thank you.
Madam, continue.
Your Honor, did you all do Mr. Scott? Curtis Scott?
No. Mr. Scott needs to be, transferred to Judge Archer. Judge Archer is gonna do it. He has another case with Archer. I know it says Giles, but it's gonna be transferred to Archer now,
Okay,
okay?
All right, thank you.
thank you.
Yeah. Is it one of the dates moved out sooner? Oh. Oh, yeah, still just move it out. They don't have to report it. We'll just adjourn at that time. Oh, thank you.
Yeah, we kind of, right, just checking. You gotta get it, James. All right, thank you. James, prisoners. Thank you. The last two prisoners, whenever we get a chance.
Huh?
The last two on the docket, 2:45, 3 o'clock. On Thursday. Okay. Okay.
Mhm. Oh, Ellis, we didn't do Andre Ellis.
This Logan, is this the brand Logan you're talking about? Because this the case you called.
He's got 3 cases. There's one at 9 o'clock, there's one at 9:30 and 10 o'clock. So the 9 o'clock is the one I called.
Oh,
You see?
okay, I see it now,
Yeah.
okay. And then the, one you were referring to.
Is what?
Scott, that's heard of Scott, Miss Shabazz case.
Yeah.
That went to Judge Archer,
Yeah.
okay.
Yeah. She called and said, huh?
Until Judge Shabazz.
Oh, no, thanks. I forgot about that. She called me and told me about this case.
Oh, who Shabazz did?
Yeah, Judge, you remember that case yesterday that Shabazz was on, and there was a co-counsel? He got dismissed, the defendants, she dismissed them because of discovery.
Yeah.
The witness came, was very upset. He started crying. He said, because they are still continuously harassing him and his family.
Contact the prosecutor's office, so refile it.
Yeah, I told him that Matthew was, because I contacted Matthew because he was so upset. And
Oh,
Matthew,
that got dismissed because they didn't like discovery.
yeah,
Yeah.
yeah.
Showing her his scar.
Yeah, he had a big old scar from his chest all the way down. He was just crying. He was really emotional. So that's why I got in touch with Matthew. And Matthew said that he was actually in the process of refiling it. So he said, I was trying to calm him down. I didn't really want to talk to him, but there was nobody else here. And he said that they got subpoenaed their subpoenas had 1:30. They just so happened to come early, because remember, it was scheduled for 12:15.
Right.
But he said they came early, because as soon as we broke for lunch yesterday, that's when they came. Yeah. Yeah, but I told him too, to make sure that he brings that up about them continuously harassing, you know, because that would reflect his bond.
Right.
But he was real scared now, because he was saying, he was like, they're out now. It's dismissed, you know, like that. They just threw it away, and I tried to explain it to him. It was about the discovery that the prosecutor didn't receive from the officer, and he was just upset, kind of like that, scared, upset.
Yeah.
I was just like, I felt bad, like, oh, I'm sorry, I can't do
Yeah, she
that.
was almost crying. She was telling
I
me
was
about
like-
it. It just moved.
I was
He
like,
showed
oh my
his
God.
body and those injuries she broke down.
Yeah, it was bad. And sometimes when you see a grown man cry, you know it's gotta be, you know, affecting him some type of way.
Like 2 hours early.
Yeah, they was like, what? Why were they on Zoom? I had to explain that. I was like, ugh. Cause his wife was with him, and I was trying to talk to more her, so because he just got too upset. And I was trying to tell her, you know, just calm him down, you know, the prosecutor's refiling it, you know. Cause he was like, how long, you know? I was like, it shouldn't be long. If he's refiling it, you know, it should be no time. I meant to tell you yesterday, but I forgot, and then I was like, oh, man, I forget it. And then, Alfreda just reminded me. I was like, oh, yeah. Yeah.
Yeah, that was assault with intent to murder.
Yeah. Then the wife, she was trying to get into more detail. I said, I don't need to hear all that. I can't do nothing for you, I'm sorry. Because she was saying it was more than just 2. She was saying it was 8 of them. So they must have jumped him or something. That's what I'm thinking. Hey, Lucky.
Lucky's not here.
Terry. Do you guys drink these?
I don't. Well, wait a minute, is that zero sugar?
Yeah. It's Gatorade Zero.
Um,
You drink these, Judge? These Gatorade Zero stuff? No.
I don't drink anything that's artificial.
Oh.
right, that's that aspartame and all that other stuff, yeah.
Stuff called
Yeah,
cancer.
you know, good for you. Now, there are 2 juices out there.
Oh, really? Gatorade does that? My
Yeah,
son
because
drinks
if
Gatorade.
it's not real sugar, they put that other stuff in there, the artificial, and it's not good for you.
Oh, he drinks them all the time.
Yeah, I have a holistic doctor. He told me he'd rather me use real sugar than that stuff.
Oh, really?
Yeah.
I didn't know that. I'm gonna have to tell him that.
But there are 2 juices out there that use a natural sweetener called it's a plant that grows stevia, and they use that instead of sugar or any
Problems with that
artificial.
stuff too.
Huh?
They're having problems with that stuff too.
Stevia?
I think so.
I haven't heard any. That's a natural plant that grows. I even bought the plant one time at a market, the farmer's market, and grew it. You hydrate the leaves and stuff, and you can grind it. You did. It's straight from the
agave.
Yeah, agave. I don't like agave.
Well, it has a little taste to it. It's not just sweet, it has a taste to it.
The stevia?
No, agave.
Agave, okay. But you got there's a juice called Core and a juice called the Bai juice. They use the stevia. It's more like a flavored water. That's what I use. I like a little grape juice every once in a while. Welch's grape juice.
Yeah, I gotta have a taste for that.
All right, now, William.
Good morning, Your Honor. I'm Mr. Moody. How you doing? Good.
Good.
We ready on Antoine Williams?
Yes, Your Honor.
Calling case number. Calling case number 2155380, the people of the state of Michigan versus Antoine Williams. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. This is Rusty Weber, people.
Good morning, Your Honor. Frank Becker on behalf of the defendant Antoine Williams.
Number.
25502.
Ready? Judge, this time we do have a one witness officer. I don't have another officer. I got an email yesterday indicated he will not be here because he has a doctor's appointment scheduled. So the first request we would ask for is an adjournment for this matter. If the court's not willing to do that, we can try to go forward with the officer.
Well, I'm not adjourning it. We had a doctor's appointment. It's not an emergency. So I'm not adjourning. Go forward with your one witness.
All right, thank you. We'll go forward. I will call now Officer Williams.
What's the officer's name? Wiggins, I'm sorry. Yes, sir. You ready?
Good?
Yes, sir. Yeah, okay.
Good morning, sir. Your name for the record?
David Wiggins,
And Mr. Wiggins, where do you work?
Detroit Police Department.
Okay, and I'm gonna take you back to the date of January 18th, 2021. And at a location around Winthrop Street. And with regards to that, is that a street that's in the city of Detroit, Illinois?
Yes.
Okay. Now, you went to that location, strike that. Or did you have a reason to go to that location?
No particular reason, sir.
Were you at that location on that date and time?
Yes, sir. I was.
Okay, were you working with anybody at the time?
Yes, sir.
Okay, and who were you working with?
Officer Lewis and Officer Lockhart.
Okay, now, you got to that location how?
I was driving eastbound on Davidson, approaching one through.
Okay, were you in an automobile?
Yes, sir.
Scout car?
Yes, sir.
Marked plate or otherwise?
Marked.
All right, and you were dressed how, sir?
In a police uniform.
Okay, and can you describe what that uniform looks like for the record?
Gray painted, black outer vest, like the one I'm wearing today.
Okay, can you tell the court whether it indicates that you're a police officer on the front or back of it?
On the front and the back of the vest, yes, sir.
Okay, how are your partner dressed?
In a similar fashion.
All right, and you got to this location, tell us what happened.
I saw a vehicle, it was initially traveling southbound, on Winthrop, as we were heading east, approaching the same street. I observed the vehicle, failed to signal, before conducting a U-turn within the intersection of Winthrop and Davidson.
Okay, now, were you driving the scout car or somebody else?
I was driving, sir.
All right. Now, is that a ticketable offense to do that in Detroit?
Yes, sir. It is.
All right, so what do you do now?
So the vehicle, after conducting the U-turn, it began heading northbound on Winthrop from Davidson, and I followed and approached the vehicle to advise on the infraction.
Okay. Did this vehicle stop?
Yes, it did.
Okay, did you activate lights and overheads?
No, I did not, sir.
How come?
Because we were only advising on the infraction.
I'm sorry, you only left?
Advising?
Oh. I mean, advising as to an infraction?
Yes, sir.
Okay, all right. So, how did this vehicle stop?
It stopped in front of a residence, to which I believe that it was a defendant's home.
Okay. Did it stop in the driveway or in the street?
On the street, sir.
Okay, so when this vehicle stops in the street, what do you do now?
I put up alongside the car and
Okay, and it is, if you could give us a little direction as to alongside the vehicle, or what part of your vehicle is closest to his driver's side window?
the passenger side, sir.
Okay, so your passenger window is closest to his driver window?
Yes, sir.
Okay, you're in the driver's seat of the scout car?
Yes, sir.
Who's in the passenger seat?
Officer Lewis, sir.
Okay, is that Lewis?
Yes, sir.
Okay. All right, and when you come up next to this vehicle, what happens?
I heard the defendant state that he had a weapon in his vehicle.
Okay, well, maybe back up a little bit. Can you tell the court how many people were in that car?
And the vehicle that we stopped to advise,
Yes, sir.
as I believe it was on one person, sir.
How many people did you see in there?
One, sir.
And the person that you saw in that vehicle, is that person in this court room today?
Yes, sir.
Can you tell us where that person might be and what that person might be wearing today?
Sitting on the bench with a black suit on, black man.
Okay, which bench are you speaking about? Is it behind this half wall here?
Yes, sir, it is.
How many seats back? How many rows back?
On the first row, sir.
All right, for the record, then, identify Mr. Antoine Williams. Okay, so you pull alongside Antoine Williams's car. And you indicated to the court what your intention was. And you indicated now what? Mr. Antoine saying overall.
That weapon was in his vehicle.
Okay. So what do you do then?
Exit the vehicle to conduct an investigation.
Okay, did you ask him a question about that, about a weapon?
No, I did not.
Okay, somebody in your car?
Yes, sir.
All right. All right, so after you hear him say that, what do you do? I'm sorry.
Exit the vehicle to conduct an investigation.
Did you exit the vehicle?
Yes, sir, I did.
Did the other officers?
Yes, sir.
Okay. So now tell us what happened on the investigation.
To my knowledge, my partner, Officer Lewis, made contact with the driver of the vehicle.
Did you see him do that?
Yes,
Okay. All right. Where did you go to?
on the same side of the vehicle, on the driver's side.
Okay, so you're standing near your
Yes,
partner?
yes.
All right. So what happened?
The occupant of the vehicle was removed, in a further investigation.
Why was it removed?
He stated the presence of a weapon inside of his car.
Okay. And he's removed. As he's removed, what happens with him?
My partner, Officer Lewis, as I remember, maintained security of him, while I retrieved the weapon from inside the vehicle.
Okay, how do you maintain security?
He was in, hand restraints, usually what happens,
Well, what happened in this case? You know where the defendant was moved to, if at all?
I don't remember, sir.
Okay. So now you indicated that you recovered a weapon.
Yes, sir.
Okay. As you recovered the weapon, where did you recover it from?
In between the driver's seat and the center console.
Okay. In relation, okay, so, in relation to where the defendant was seated in his vehicle, where was this weapon?
It would be on his right side.
Close or far or where?
Close. He was sitting down and the weapon was, wedged in between the seat and the center console.
All right, now, when you recover this, what do you do with the gun?
I made it safe, by removing the ragged magazine and, locking the slabs to it.
Okay. And is it marked as evidence?
Yes, it is.
All right. At any point in time, can you tell the court whether or not a CPL was produced?
It was not. It was not.
Okay. Without prompting the defendant to say anything, you're asking anything about the weapon, did he say anything at all?
Your Honor, I have to object to that because he's already said that there was a question asked, is there a weapon in the car? So to say now without prompting, the vehicle was stopped and then they asked, is there a weapon?
At that point, he doesn't arrest.
Right, so there was definitely prompting, so I think that's an unfair question. It could be misconstrued. Thank you.
I thought you were talking about after the first thing.
Yes.
Okay. Then, their foundation, he was given his Miranda right.
I will be under arrest. Was at any point in time at that stop or encountering you, the officers, was he given his Miranda rights?
No, sir.
All right, thank you. At any time, did he say anything following his first statement? Did he say anything? Unprompted.
Just that, he lived there and that the weapon was registered to him.
Anything else you did with this case, sir?
No, sir.
Nothing further, thank you.
Officer Wiggins, the police report we have indicates that you're the one that asked if my client had a gun. Is that possible that you were the one that made that inquiry?
I don't believe so. I was sitting on the driver. Can I ask?
Of course.
Okay, I was sitting on the driver's side of the car, operating the scout car, and then my partner, Officer Lewis, was sitting closer to the defendant because the two vehicles were paired.
Isn't it true that the Detroit Police Department and virtually every law enforcement department keeps logs of their activity?
Yes.
And how many other traffic stops do you make that day?
Objection, Judge Relevant.
Your Honor, the relevance is that we believe this, my client was targeted as a young black man driving a car. He committed no traffic infraction.
How many other stops?
I don't think that they were on traffic detail. Could I ask that question?
Yeah, that question.
Okay, were you on traffic detail?
Can you clarify the question?
Were you there to determine if, to make traffic stops?
Yes, sir, that's part of my job.
Okay, how many other traffic stops did you make that day?
Objection, Judge
That
Relevant.
Your Honor, I think it's very relevant. I would like the logs too to be produced. I don't have his logs.
Well, they're not gonna be produced right now, and I don't think it's relevant, but move on to something else, please.
Well, if this is carried
You can-
over.
As counsel, I just made a ruling. If you don't like my ruling, you get to appeal it. But you got to live with it right now.
Yeah, Your Honor, I was just trying to argue. Now, it indicates in the police report here that my client made an improper U-turn. Do you think you made an improper U-turn?
Yes, sir.
Okay. Now, what law are you relying on? What statute regarding making U-turns are you relying on?
I'm not sure specifically, but I do know that before conducting a U-turn within any intersection or upon any public roadway, that you must signal the U-turn before you complete it.
Okay. Now, you've indicated that my client made a U-turn in front of his house, basically. Is that correct?
No, sir.
He made a U-turn. He had to make a U-turn to get to his house. Is that correct?
Yes, sir.
Because it's a one-way street?
No, I do not believe that.
My client actually stopped in front of his house. Is that correct?
I believe so, yes, sir.
And somebody actually came from inside the house, his girlfriend, who also lived in the house, right?
Yes, sir.
And she verified that he lived in that house, right?
Yes, sir.
And my client was very cooperative and friendly the entire time. Is that a fair statement?
Yes, sir.
Now, in your report, you don't say he made an illegal U-turn. You said an improper U-turn. Is that right?
Yes, sir.
And why do you think, why was it improper? Because he didn't signal?
Yes, sir.
In your report, you did not indicate he did not signal. You know why you didn't say that?
May I use my report to refresh my
Sure,
recollection?
sure.
Yeah, show it to them.
I thought you were gonna use that copy. I'll approach the witness.
Yeah.
Your Honor.
Can you ask the question again, sir?
Okay. In your report, does it indicate that the U-turn was illegal? Or does it just say it was improper?
After refreshing my recollection and reviewing my report, it states that the U-turn was improper because he failed to signal. So I'll affirm both statements.
Now, when you're turning into your driveway, if you're turning left in your driveway, you're saying that you need to signal?
No way to stop.
Okay, I think it's a comparable.
He wasn't even in the driveway, he parked on the street.
Right, well, that's comparable if you park in front of your
Well-
house, Your Honor, I think. I think it's a comparable situation if you're turning left to park.
But that's not the situation here. He made a U-turn to go back to his house.
Well, let's clarify that.
He did not, no, I got the testimony like 3 times already. He didn't signal. So the officer went to approach him to let him know you gotta signal. He didn't say he's gonna write him a ticket. He didn't do a traffic stop. He didn't put his lights and sirens on. He just pulled up next to him. So, you know, and he was parked on the street. So there's nothing about parking in a driveway. It's not comparable, it's completely different. This driveway is private property.
Let me clarify, what was the distance from the, which you say to be an improper U-turn to when my
Okay, I
client
need your
stopped
approach.
his vehicle?
I need your approach. Approach, please.
Your Honor, this is my
Approach,
question
please.
on this issue.
Approach over here. In the back here. All right, anything else, Councilman?
No, Your Honor.
Judge, people have no further questions of this witness.
All right, Councilman Williams, you step down.
Thank you, Your Honor. Okay, Judge, at this time, we have a witness who did not show Officer Lewis. We have no further witnesses to go forward.
Event any witness?
No, Your Honor, we're not going to have any witnesses. Your Honor, at this time, I make a motion to dismiss this case. I think the information should be quashed. There's absolutely no reason to stop my client. There's no reason to make an inquiry as to a gun for a person that's stopping to park in front of his house. If there was no Miranda warnings given, as this court has clarified, so I would request that the case be dismissed at this time.
Judge, we would just indicate that at least the officer, he did have a purpose or a reason to stop the vehicle, as the record indicated. The officer that we do not have here, will be a component of our case, and I would reserve
All right, well, that's a motion. I believe the officer did have a reason to stop them. His intent was just to give a warning about, signaling before doing the U-turn. However, then one of his partners asked the defendant whether or not there was a weapon in the vehicle. This was done. There's nothing on this record that shows reasonable suspicion that a crime was afoot for him to investigate whether or not there were weapons in the vehicle. And as such, he had no right to ask that question. It's a violation of defendant's Fifth Amendment right. And as such, the court's going to dismiss. Congratulations.
Thank you, Your Honor.
All right, thank you.
Did you say fourth or fifth? Fifth. Okay. I want to make sure I have a note. Right.
Hi, Miss Kitty, I'm here to spend more quality time with you. Yes, can you pass me my waiver form for this one? The real concern is the 10 o'clock. Thank you.
Excuse me.
Yes, sir, Ms. Ellis.
Are you guys still in the middle of a court case?
No, we just finished one. We're still waiting on your attorney.
She should be on. She called me.
Oh, she's on.
Yeah, she called me.
All right.
All right, just hold on, we'll get to you in 1 second, please.
Okay.
Just want to make sure you can get consent. Just the memorandum. Okay. What was the bargain? So then this should be good.
Yeah, put your client's DOB on there.
Okay. You should put it on there. They say the work, you should put it on. Yeah.
Oh, sorry, I apologize. Miss Kitty, you got a napkin back there?
What?
Paper towel?
Oh, you will.
Yeah, it's
Okay.
good. I don't have no more.
Okay, yeah, you take care.
There's some wipes right here.
Oh, thank you.
Should I wait outside? Yes, sir.
Can you call it?
Huh? Ready on DeAndre Ellis, calling case number 2057865. The people of the state of Michigan versus DeAndre Ellis. Defendant is charged with count 1, weapons carrying concealed. Count 2, false report or threat of a bomb, harmful device. Count 3, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P-84724.
Good morning, Mayor. Please, this most honorable court, Rena Mitchell appearing on behalf of Mr. DeAndre Ellis, who's appearing by Zoom. Mr. Ellis, could you state your name for the record?
My name is DeAndre Ellis.
Just turn your video back on, please.
Your Honor, I'm asking for you to set this for a preliminary examination.
It's not. Is my camera on, ma'am?
No, we can't see you yet. It's still dark.
All right, have you witnesses?
Your Honor, the people intend to call, I believe it's 3 witnesses.
All right, August 5th at 11:15.
Your Honor, is it okay if I ask the defendant for his telephone number?
Yep.
Mr. Ellis, could you give me your number, please?
Hello?
Yes, could you give me your number, please?
Yes, my number is 3. Can you guys see me?
Yeah, we can see you now.
My number is 313-799.
799.
5297. I'm sorry.
Okay, I'm about to give you a call right now, okay?
I didn't understand you, man. What you saying?
I said I'm gonna give you a call right now.
Okay.
All right.
All right, Ms. Mitchell? You can hang on this.
Yes. I'm sorry. Yes, Your Honor.
We do our PCCs at 8:30. Okay?
Okay.
Thank you.
Ready on Brian Logan?
Yes.
Calling case number 206021, the people of the state of Michigan versus Brian Logan. Defendant is charged with count one, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for examination.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. May it please this honorable court attorney Phyllis Gaten Robinson, P71733, on behalf of Mr. Brian Logan, who stands over my left shoulder. Mr. Logan, can you please state your name correctly? Your Honor, today is the day and time set for preliminary exam in this matter. Mr. Logan is aware of the fact that the people have to prove that probable cause exists that a crime was committed, probable cause exists that he was a part at that time, and that he has been charged in the proper venue. He has made a conscious decision to waive his exam and be bound over to the third court. Is that correct, Mr. Logan?
All right, people have any objection?
No objection, Your Honor.
All right, Mr. Logan, you do understand that you have a statutory right to preliminary exam with a statement show by probable cause the crime was committed, and by probable cause you had something to do with committing. You understand that? Anybody promise you anything or threaten you in any way, you should waive your right to preliminary exam. You waiving your right freely and voluntarily after having the opportunity to talk to your attorney. You sign the waiver of examination form? All right, court will find that you freely and voluntarily waive your right to preliminary exam as found over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 4th at 9 o'clock.
Thank you, Your Honor.
Bond continue. Thank you.
Next one's 10 o'clock. Phyllis. Oh, you are next one too.
Oh, Brian?
Yeah.
Yeah, we're waiting for that one at 10 o'clock to see if the witness appears. That's the one. Yes. How's your daughter doing?
Which one?
The baker.
She's still catching it through the city.
Okay.
And every time, you know, they send an inspector out, or send a different inspector out, and they come up with a different,
Than what the last one
you know,
said.
now they told her she had to add a bathroom, another bathroom. She got one bathroom for the public. They told her she had to add another bathroom because of the size of the building. You know, 'cause she has indoor seating. She said, well, we took away the indoor seating. It doesn't matter, gotta add the bathroom. So it's been over a year trying to get a license. You know, she's still working, you know, she's still doing baking and, you know, people calling in orders and stuff, but.
That's crazy.
It's great, yeah.
But it seems like you should be able to have a written instructions from the last inspector, like this is what you need to do to fall into compliance.
Right.
So that when the next person come out, they can't tell you something random that
That's
was
the
not
problem.
told to
Every time
you.
they come out, it's like, okay, we got a new inspector. Oh, you gotta do this now. You gotta do this now.
So the inspectors, is there a way for her to pull her file and go down there and say, hey, listen, these were the instructions I was given. I followed these instructions. I spent X number of dollars.
Well, the problem is, you couldn't even go down there. But they won't even open.
This is,
You know,
that's crazy.
so, yeah, it is.
I mean, at this point, it seemed like she could have got a food truck and just did her thing out of a food truck for this type of money she's spending.
Yeah, well, not exactly, but hard to take out of a food truck.
Yeah. But you know, they have spaces where you can rent.
Yeah, no, that's what she was doing at first. She was doing it through, she went down Eastern Market, but she ended up going to a place in Southville.
Okay.
And that's what she was working on initially.
The shared kitchen.
Yeah. Yeah. So we're hoping she'll be open soon.
Wow. And you said her bakery is right on the border of Grosse Pointe?
Okay. That's on Mac.
Okay.
Right at the, before the turn.
Uh-huh. That's crazy. That's a headache like no other.
Yeah.
That's about as bad as this
She's
landlord
been across the
trying to get
street.
tenants out.
She has been across the street. She's been open a long time ago.
Make it hard for you to be honest and do business.
Yeah.
Your other daughter, how's she doing?
Good. They're all doing good.
Okay. You know, I just asked about the baker because I'm a baker.
Yeah.
It's not that I don't care about the other ones. I just think about her all the time because people keep trying to tell me, why don't you think about opening a bakery? And I'm like, no, you know how much more labor intensive being a baker is as opposed to being a lawyer?
Yeah, that's hard work.
Like, when I do pop-up shops, that is more than enough. I enjoy it, but physically, that and chasing a 2-year-old. Yeah.
Well, the thing is, Lisa, she got 6.
She got 6 kids?
Yep.
Jesus. How old are they?
Oldest is, Rick is 14, I think just turned 15. Just turned 15.
Okay.
And the youngest, Ronnie is 5.
Wow. Yeah, absolutely. She's real MVP for real.
Yeah, she does it. Keeps it all together, I have to give it to her.
I was probably just sitting on my front porch sucking my thumb with 6 kids, like they in there doing something to the house, but I don't know what they're doing, but they're doing something. I just came out here and waited for you to get home, go figure it out. Wow.
Yeah.
Randomness, I dated a guy, he was like, God said you're gonna be my wife, we're gonna have 4 kids. I said, well, I know you're not gonna be my husband, because I know God don't intend for me to have more kids than my mama had, because I ain't have to, my mama was. You sound great. Certified. All right, wonderful, thank you. Your Honor, we might be ready to move a little bit early, we said that this is here on 10 o'clock.
Okay, all right, I'm just gonna do some water, I'll be right back.
All right. You?
I'm with it again.
So what you do, save that water for it till you went to work last night?
No, I took it home. I dropped it in my truck.
Oh, yeah.
Hey, how you doing?
Good morning.
What case are you? Let me see. That's a hotel in Green.
Which one is it? Scott? It's right here in the corner.
Yeah.
Oh, that's the hair.
Right here, is this it?
Say Scott. I don't know what that mid is.
Yep. That's somebody else.
Oh.
Tammy's here to get this file.
Oh, Tammy, I'm sorry. I tried calling you.
That's okay.
I tried calling you.
That's okay. We got it.
Thank you. So you do have the odor case?
I recognize his name.
Oh. Because I wanted to make sure with you, but she said.
Yeah, that's okay.
All right, thank you.
Oh, no.
It worked out.
I forgot about that. I had it sit right here.
It worked out.
Tammy, she's so sweet, so.
Curtis Scott, GOT.
So I guess they ready, Logan?
Yes, you should be.
All right.
Went two so far.
Three cases.
Okay.
Huh? Started raining. Yeah. It was cloudy, windy. Oh, well. I get to it. Yeah, they cut my bread. Huh? I ain't getting mine. I took care of some other stuff I needed to take care of. I had, when it got prices on wood, and I had a couple of people, check out, y'all the same price of wood pattern. Oh, whatever happened with, Kwan? Huh? Kwan, did he, they came over, they gave us, estimate. And what they did with the shit is, they didn't break it down, but it's cool, because it worked out about the same. I'm just working on this project with my trailer. Yeah. So if they don't mind, because his wife came with him too. And they don't mind, I just do one. The other people was maybe just a little bit under. Yeah, it's not as available.
Are you gonna load it? Are you gonna load it?
Yes. Well, no, I haven't talked to her. Which one is this, Blair or this young lady?
Judge, on this Akia Bailey, I put in, but I'm not sure if they'll do a report. If there's a personal bond on this one.
Oh, they won't.
I can't remember if they.
Yeah. I don't know if they're. That's the one I asked was VS1, was it?
Yeah. I wonder if there's.
Also, still miss that, right?
Yes, ma'am.
I think that's what I was told earlier.
Okay. Appreciate it.
Ready? Ready on Brian Logan?
Yes.
Calling case number 2061383, the people of the state of Michigan versus Brian Logan. Defendant is charged with count 1, robbery armed, count 2, weapon felony firearm. This matter is scheduled for examination.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. May it please this honorable court attorney Phyllis Gaten Robinson, P71733, on behalf of Mr. Brian Logan, who is behind me across my left shoulder. Mr. Logan, can you please state your name for the record?
Brian Logan.
Yes, Your Honor. People are prepared to proceed today. All witnesses are currently sequestered as our officer in charge is not here today for COVID reasons.
Now, we were trying to let me proceed first, and I'm prepared to move forward.
You know, witnesses testifying today at trial, anytime in the future, must be the program or be denied.
At this time, people call William Puritan.
There are some, the truth, the whole truth, and nothing but the truth shall be known. Yes. So, here for the have a seat. All right, Mr. Puritan, you're going to be asked a series of questions, first by the prosecutor, and the defense attorney will ask you some questions, and I may or may not answer questions, all right? You have to answer all your questions out loud verbally using words. Just can't shake your head up and say yes, no, whatever the answer is. Also, when you ask a question, I need you to just answer the question and stop. If it's a yes or no type question, just say yes or no, and, leave it at that. If we need additional information, we'll just ask another question, all right? We all have a tendency when we're talking, or when we're talking about an incident, especially one that's been traumatic, we tend to ramble. We'll say this happened, and this happened, and this happened, and this happened. If you do that, I'm gonna miss something. All right, I know nothing about the case. I got all my information about the case like in the courtroom. That's why we go one question, one answer at a time. That way I can understand. Okay? And then last but not least, because of the mask and the barriers and all that, it's sometimes very difficult to hear. I need you to please keep your voice up. You can talk directly into that microphone in front of you, put it down if you want to. And that will help amplify your voice.
All right, thank you. May we proceed?
Thank you, Your Honor. Mr. Curtin, please state and spell your name for the record.
It's William Curtin, WILLIAMCURETON.
Mr. Curtin, I'm going to take you back to the afternoon of October 17th of 2020. Where were you on that afternoon?
I was at East Jefferson Liquor Store.
Are you familiar with the location of 10520 East Jefferson?
Yes,
Is that in the city of Detroit County, Wayne?
yes.
What's at that location?
It's a liquor store.
Is that the liquor store that you just mentioned a moment ago?
Yes.
What happened when you went to that location?
When I went to the location, I went in to cash in my check.
How much was your check worth?
It was like $300 and some odd.
Did you in fact cash in your check?
Yes.
After you did that, what if anything did you do?
I came out the liquor store, and then the young man opened my car door.
I'm gonna back you up for a second. You said you came out of the liquor store and then you mentioned a car door. At any point did you get into your car?
Yes, I got into the car.
After you got into your car, what if anything happened?
A young man approached my door and opened it.
Would you recognize that young man if you saw them today?
Yes,
Do you in fact see them today?
yes.
Please point to them and identify an article of clothing that they are wearing.
Right here with the blue shirt on.
Let the record reflect that the witnesses identified the defendant.
Your Honor, I don't see anyone in the courtroom, I'm sorry, I don't see anyone in the courtroom with a blue shirt on.
Mr. Puritan,
Tell me where the person that you just pointed out is sitting.
Right here in the bench seat.
That's on the other side of the half wall.
Yes.
The court will, may have identified the defendant.
Mr. Puritan, did you know the man that approached you?
No.
What, if anything, did that man do?
He opened my car door with a pistol. And then he got in.
When you say that he had a pistol,
Yeah.
where, if anything, did he have that?
In his hand, like in his shirt.
Where was the weapon pointing?
It was pointing towards me.
Could you see, were you able to see the weapon in plain view?
Yeah.
Did that man say anything to you?
Yes.
What did he say?
He said, I need it, cuz. And then I said, what? He said, I need it. So I gave him my glasses and my money.
When you said that you gave him your glasses, what kind of glasses did you give him?
A pair of Cartier glasses.
Do you know approximately how much those are worth?
Yeah.
How much?
$1,300.
Did you give him anything other than your glasses?
I gave him my cash,
How much cash did you give him?
probably like $450 or around that area.
Did that man take the items that you gave him?
Yeah.
Did he say anything else to you?
Yes.
What did he say?
He asked me to have a gun.
Did you have a gun?
No.
What, if anything, did the defendant do at that time?
He like patted me down a little bit.
After he patted you down, what, if anything, happened?
He said, I got my car keys or something like that, and then he got out, got in his car.
Mr. Puritan, while this was happening, what, if anything, were you thinking or feeling?
I was just hoping that he could shoot.
Why were you hoping that he wouldn't shoot you?
Because I had a family.
One moment, Your Honor. Your Honor, no further questions at this time. Yes, ma'am.
Mr. Carrington, am I saying your last name correct, sir?
Yes.
I'm gonna try to talk loud, but I have on double mask, so if you can't hear me, please say so and I'll try to project some more. Can you hear me okay?
Yeah.
Okay. Sometimes I talk fast. If I start talking fast and you cannot hear me, please do me a favor and let me know and I'll, slow down. If I say something you you don't understand, I'll repeat it or say it a different way, okay?
Okay.
So on this October date, can you please tell me, you said that you encountered someone at the liquor store, is that correct?
Outside of it, yeah.
Outside the liquor store. What were they, what was that person wearing?
Yeah, I don't know, gray jogging suit, a mask, and, you know, gray gym shoes.
Okay. He had on a gray jogging suit and a mask. How much of his face was covered by the mask? So this is the thing. She's recording the record. You have to describe in words what you're saying because this isn't a recorded record.
The nose down.
From the nose down? Okay. And you indicated that you did not know this person, is that correct?
No, I did not.
Okay. And have you interacted with this person? Did you interact with this person or see this person inside the store or just outside?
Inside.
Inside the store. Did you interact with the person inside the store?
Couldn't hear you.
Did you interact with the person inside the store?
No.
Okay. You indicated that you indicated that this person had a weapon, is that correct?
Yes.
What type of weapon was it?
Like a black revolver.
A black revolver? Okay. And you said that when you exited the store, did you hit the locks for your car or was the car unlocked?
It probably was unlocked.
Probably was unlocked, okay. And so you got in your car, is that correct?
Yeah.
And then what happened?
I walked up to my car door.
Okay, and then when that happened, did you attempt to get out of the car or did you just stay in the car? Were you already seated in the car?
I was already seated in the car.
Okay, okay. And then when you all had it, how long was this interaction inside the car?
Maybe a minute or two. I'm not really sure.
Okay, okay. No further questions, Your Honor.
Free for director.
Yeah.
A moment ago, defense counsel asked if you got out of the car. Were you able to get out of the car?
Yeah, I got out of the car when I went in the store.
I'm sorry, I'm back up for a second. When the defendant approached your vehicle and opened the door, were you able to get out of the car at that time?
I mean, yeah, I could, but he had a gun.
No further questions.
Any further?
No, Your Honor.
Thank you. Thank you, Mr. Carroll. You sit down.
Your Honor, people call no additional witnesses for exam purposes.
Ben?
Your Honor, for the purposes of preliminary exam, we do not have any witnesses.
Your Honor, at this time, the people respectfully move to have the defendant bound over on 2 charges. The first, robbery armed, the second, weapons felony firearm. We heard from the complainant witness today who stated that after getting into his car, the defendant came over, opened his car door, had a gun that was visible to the complainant, that he made statements to the complainant saying, "I need it." The complainant then handed over his glasses and the cash that he had just extracted from the liquor store, both that had monetary value, handed those over to the defendant, that the defendant, after committing that larceny and placing the complainant in fear, then left the premises. At this time, we believe that any further issues are an issue of fact for a trier of fact and should be dealt with at the search court level.
Your Honor, we'll leave it to the discretion of the court.
For having heard the testimony, Iron Time taken as follows. William Charlton on October 17, 2020, in the afternoon was at 10520 East Jefferson, which is a liquor store, went in to cash the check. Came out, got into the car, the young man approached, identified the young man as the defendant. Opened his door, he had a pistol, he got in, pointed the gun towards him, said, "I need it." approximately $450 and cardiac glasses. He asked him if he had a gun, he patted him down. Then he got out and got his own car and left. The question of fact. Or find that felonies enumerated in warrant did in fact City of Detroit, all this discharge defendant was found over the Wayne County Criminal Division for arraignment on the information. Will be made for him. And I'm like,
Thank you, Your Honor. Thank you, Your Honor.
Three cases get added to the case you already have in front of one. Sir, have a fun summer with your kids. Take a lot of pictures.
That's too much.
Have a great day.
You too.
I'm not sure.
All right. You ready on Jordan Glenn?
The attorney's here.
If we want a bond argument on Logan, is it too late to call it? Huh? If we want a bond argument on Logan, is it too late to call it?
When you get home,
I will. I think he's over his Kiki's house and
Yeah,
manipulating the system at this point. There really no rule at Kiki's house. Other than don't say no to him.
But that's the case, we make a further bond argument over there.
Is it there?
The advocate's still here, the defense counsel's here.
Yeah.
Okay.
We'll bring him in.
Recalling case number 2061383, the people of the state of Michigan versus Brian Logan. Defendant is charged with count 1 robbery arm, count 2 weapons thrown in firearm. This is a bond hearing.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, Your Honor. Attorney Phillips J. Robinson, P71733 on behalf of Mr. Logan, who stands across my left shoulder.
Your Honor, at this time, people have requested a bond motion. This current defendant has 3 felony cases that were found over this morning. One of them is an armed robbery case. The complainant is nervous, justifiably so. They are now, for each one of those cases, probable cause has been seemingly established, and we've dealt with the circuit court level. We would like to ask the defendant to have a
Yeah, he currently is on tether.
He's on there?
Yeah.
Then thank you, Your Honor.
We didn't.
Okay, no problem.
We will note our files so this does not happen again. Thank you.
Okay.
Thank you,
All right.
Your Honor. He's currently on tether.
What's going on with Jordan Glenn?
So the defendant, but we have an attorney.
Oh. You don't know where your client is? Ready on Jordan Glenn? Calling case number 20609588, the people of the state of Michigan versus Jordan Glenn. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. This is Prosecutor Glenn. Good morning, Your Honor. Spencer Clayton, hearing on behalf of Mr. Glenn. Your key number 77302. Your Honor, Mr. Glenn is not present. I tried to reach out to him several times this morning, wasn't able to get a hold of him. I don't know where he's at today.
Conditional enter. Any bond conditional enforcement, bond set, 30,000 cash.
Thank you.
Counsel, can I get your name? Oh, it is, okay, this is Mr. Davis. Yeah. Okay, he's 762. It is. Very good. All right, thank you. Thank you.
Take care.
Yes.
Bates here? Oh, that's 10:30.
Stop shelter. Yep.
We didn't do her to Scott yet, did we? Oh, no. Okay.
Yeah, I think that's what Kane did.
That's what? Judge Archer?
Yeah.
Oh.
He had another
No.
case.
How come it went to Archer?
Yeah, the previous case.
Oh, gotcha. Okay. All right.
Judge, are you doubling up on these? Dates? September 16th? September 16th?
September 16th. I think I did. Yeah, 9:15, 9:45, 10, and 10:30. Before.
Because you remember I adjourned them dates to September 16th.
16th?
Yep.
I thought it was other days. That's why I wrote the 16th.
The first ones were. The first dates you gave me, I adjourned to September 15th, 16th, and the 17th. For June 23rd, 24th, and 25th.
So I didn't think those out. We didn't say, so we can move these One,
Well, then, yeah,
because I set some for the 15th and the 16th.
yeah, which is, I just realized it's probably gonna double them up.
Yeah.
I'll run a docket and see how they look
Okay.
right now.
We also adjourned for, following week, the 24th
Yeah, yep,
and the 27th through the 1st.
yep.
Because I didn't start putting them back down until October 6th. We did the 4th and 5th too.
Yep.
Okay. So I started on October 6th.
Right.
Okay.
Yes. You need me?
May I ask a quick question?
Uh-huh.
Joshua McCormick, did Maurice Davis ever enter appearances on those?
Yeah, he did.
Because there's one in Archer too, and he never did anything about that one.
That one, I don't know about that one.
I think the ROA still reads my name. And I just don't want anyone calling me up and yelling, where is?
The one with me.
So you have all three cases then?
Huh?
You have all three cases then?
I don't remember if we have all three.
All
I know
right.
we just did McCormick, yeah.
It is, but I think he has two other cases coming up soon. I don't know if it's an adjourn.
You want me to check?
No, you don't. I just want to know whether he did anything you seem to think he did.
On the one he did yesterday, yeah, I know he did, but
Okay.
I don't know about the other ones.
You talked about one other case. You didn't say nothing about two other cases.
Yeah.
You talked about one other case.
So he's got two, I know he has two cases with you. I think he has one case with Archer too. And that's the one David Cripps is, has the co-defendant on.
Oh, we need to see who has the oldest case. We didn't get all of them.
Well, we did one of ours.
All right,
Right.
I just want to know, and I'll talk to Archer's court again. He never contacted me in the first place. And I think you called me up saying, where are you, or something like that. Or,
Was it on that case?
I don't know, he's got
Was
three
it
cases.
McCormick?
McCormick in Archer's room has a co-defendant as well. Cripps has the co-defendant.
What was his first name?
Joshua.
Josh.
Joshua fit the battle.
Only does have three. But he only has one left. 2, 1. Yep, he got a third one with Archer. That's the one he's talking about. Yeah, your name is on it.
All right.
You're on that one. That's a new one.
The one with Archer's the one that made the
Archer's new.
newspapers.
Let me see what the other ones are.
Has it been a PCC on it yet?
Yes.
You set it for exam, or you set it for another PCC?
I don't remember off the top of my head. I think it's set for another PCC. And I think she's into September with her stuff.
The one we did was bound over.
Well, then if we got them on the older case, then that one should come to us.
You had the assault with intent to murder, and I think maybe just a regular old car case.
Yeah, we had assault with intent to murder, and she's got a receiving and concealing. Motor vehicle.
That might be a little bit more complicated than just receiving and concealing, but still. All right then, I'll sort it out. I just wanted to know whether,
Well, we're probably gonna snatch and bring it up here then.
if you could just let me know. Thank you, Judge.
You're welcome. Sure, she won't complain about that.
Yeah, both of them were bound over.
Yeah, you got the oldest one, then we should have that one too.
I'm sure she.
Yeah, I know she will.
Oh, so we ready on Bates? Jordan Bates. Ready on Jordan Bates. Calling case number 2-1-55915, the people of the state of Michigan versus Jordan Bates. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. Habitual offender, fourth notice. This matter is scheduled for examination.
Good morning, Your Honor. Rick Duffler on behalf of the people, P84724.
Randall Upshaw on behalf of defendant, P number 43574.
How you
doing, sir? Jordan Bates.
Thank you.
Yes, sir.
Are you ready to speak?
Yes, Your Honor.
Your Honor, at this time, the people are not prepared to proceed. Our main officer has not yet come to court. It's my understanding that the clock just turned 10:30. He is failed to appear. We're not able to proceed at this time.
Your Honor, this time we have a request for dismissal.
You have a dismiss? Yeah. All right. What Melly girl? We haven't seen that in a while. Who? Haven't seen Melody in a while.
She's old, she's working, and I'm waiting on her to just kind of take another 20%. Yeah, she's on Zoom somewhere right now. That's the whole thing, we're about to crush, happen sooner or later, when trial starts.
Right. Yeah, they're gonna, more than likely, they're gonna pass the docket. We'll bring in another different governor.
Yeah, that's gonna be scary though. That's scary.
Yeah.
Because at the last, let's say at the last minute, if the prosecutor decides to change something, they're saying you can't. Yeah, that's, you should all, even though you shouldn't expect anything, but if they walk up at the last moment and see a blurb in there, you know, offense, then you should be able to offer something. They're trying to make the rule that you can't make an offer at trial. But again, let's live through this and everyone be safe. Let's see.
All right.
All right.
All right. All right. So do you think any of the guys would want them waters?
I can ask.
If not, I'll just put them in the
What waters? So Gatorade.
Gatorade.
Zero, no sugar, but it's
Oh.
got that other stuff. I will take one. If you offer them.
I mean, you can stick them back. I don't want them. I buy them for my son, but he don't like the zeros.
Oh,
So, I mean, what am I do? I ain't taking back.
okay. Jerry might take them too, other than he drink like less sugar. I'm gonna just take one out. Okay.
Is anybody in y'all office back there?
It will be.
There's somebody back there? I'll just take them back there.
I can put them in there.
Oh,
Yeah.
yeah, I don't want them. You know what I'm gonna do with them. I don't drink them.
Okay.
All right, what's our next one? Kane Thomas?
Yeah. Have you seen or heard from Ms. Farkas?
Nope, she'll be here.
The defendant is here. He's been here for a while.
Oh, for real? All right, let me go see who my doctor's office called me. Oh, Lord. Who's there?
Say that little puppy. Give him more time. I said, you know, our son came with that puppy I was talking about. Oh, yeah. She takes up a little bit more time than I need to be taking up.
Those, some of these officers are killing.
Yeah.
Some of them aren't great cases, but other ones are great cases. I just wish they'd show up.
Would help. Go this far and then they don't show up and then all this work for nothing.
Honestly, yeah. He's outside talking to someone
Oh, okay.
on the next case, so hopefully that one will release go. Although I don't see the officer looking yet on that.
Oh.
They were here yesterday though, so maybe that's a good sign.
Yeah. I guess they so short. I don't know why they don't show up for court. today. Yeah. Salmon again and vegetables this time. Wife cooked salmon. Just a little bit overcooked, but work. Hey, how you doing, sir? Morning.
Is Mr. Kelly signed yet?
Kelly?
Yes, Adrian Kelly.
Kelly, it's 11 o'clock, yeah, he's not here yet. Do I see?
I am. I'll be in the hall. I'm waiting for my officers.
Okay.
Thank you.
Which case are you doing, please?
Dante Thomas, Jane Thomas.
Okay.
Yes, John, coming to 10:45. Thomas Kane. We know the attorney. Right, didn't think we need this today, sometimes I appreciate it. Targets.
Stephanie? Three one three, 418, 55, 56.
Last six. All right, you see it fine?
Yeah, he's up
We'll probably call it on the third, right?
Okay.
All right, Frida. What's going on today?
A whole lot.
Come on, well, I can't kid you.
Work early this morning.
Huh? Oh, yeah. Are you okay, Tommy?
the social distancing rules. Morning, Judge. Morning.
Morning. We ready on Deontay Kane Thomas?
Yes. Yes.
So, calling case number 2155239, the people of the state of Michigan versus Deontay Kane Thomas. Defendant is charged with count 1 and count 2, controlled substance, delivery and manufacturing cocaine, heroin, or another narcotic less than 50 grams. Second notice. Count 3, controlled substance, delivery and manufacturing, second notice. Habitual offender, second notice. This matter is scheduled for examination.
Good morning, Your Honor. Elizabeth Moore on behalf of the people of P84724.
And good morning, Neighborhood Defender Service Site 7 Marcus, P74227, appearing on behalf of Mr. Kane Thomas, who's present and seated behind me. State your name for the record.
Deontay Kane Thomas. All right, ready to go forward?
Yes, Your Honor. People are prepared to proceed. We do have one preliminary matter before the court.
Defense is ready to proceed, Judge.
Your Honor, at this time, we do have a preliminary analysis for narcotics. Would Your Honor prefer that that be read into the record prior to testimony or after testimony?
You seen it?
I have, Your Honor.
Any objection?
No, Your Honor, my reading is that the people have the ability to introduce it for any statute.
Well, you can do it once we get to that point.
Thank you, Your Honor.
At
At this time, we will call Officer Giles.
Where are our go through for your fingerprints that we have. So the door for you, please.
Good morning. Please restate and spell your name for the record.
My name is Officer Michael, Michael, Stokes, Stokes.
Are you currently employed?
Yes, sir.
Where are you employed?
The Detroit Police Department, Southern Precinct Special Operations. 7.
How long have you been employed as a Detroit police officer?
I have been there since August 26th of 2019.
Let me take you back to the date of January 11th, 2021. Were you working on that day?
Yes, ma'am.
Were you working in your capacity as an officer?
Yes, ma'am.
Were you working with any individuals on that day?
Yes, ma'am. I was with my partner, Officer James, James. Last name is Reeves, Reeves, Victor, E.S.
What were you wearing on that day?
I was wearing my full special operations uniform.
And were you traveling on foot or in a car?
I was in my partially marked out vehicle.
Were you a driver or passenger in that vehicle?
Driver.
Did your duties as an officer take you to the location of Holcomb and Harper?
Yes, ma'am.
Is that in the city of Detroit, County of Wayne?
Yes, ma'am.
What were you doing in that area on that day?
I was traveling eastbound on Harper, and I observed a white Cadillac that was going, it turned off of Harper and it went southbound Holcomb.
What, if anything, did you notice about that white Cadillac?
There was no license plate and there was no temporary tag.
After you made that observation, what, if anything, did you do?
I conducted a traffic stop.
And after you conducted the traffic stop, what, if anything, happened?
I approached the vehicle, asked the driver if there was any, or why there was a plate or temporary tag in the vehicle, which he said he just got the car. I then asked for license, registration, insurance, if he had any of that. And I was handed a Michigan identification card and the title for the vehicle.
Now, officer, I want to back you up for a moment. How many occupants were in the vehicle?
One.
And did you personally make contact with that driver?
Yes, sir.
Would you recognize that person if you saw them today?
Yes, sir.
Do you in fact see them today?
Yes, sir.
Please point to that individual, identify where they are seated and an article of clothing that they are wearing.
Black dress shirt and the bench seat behind the wall.
Let the record reflect that the witnesses identified the defendant, Dante Kane Thomas. Now, officer, a moment ago you stated that you asked the defendant for materials. What did you ask for?
License, registration, insurance of the car.
Did the defendant provide any of those items?
Only a identification card and the title for the vehicle.
Did the defendant indicate that they had a license?
No.
What, if anything, did you do at that time?
I then had Mr. Thomas step out of the vehicle due to the fact that there was no identification for the car and there was no licensed driver driving the vehicle. So at that time, I detained Mr. Thomas for further investigation.
What did that further investigation look like?
I knew as soon as I detained Mr. Thomas, I was going to be towing the vehicle. So I walked Mr. Thomas back to the front of my scout car with my partner. And that's when I conducted the inventory search of the car.
Why did you conduct an inventory search?
Because we do that every time we tow a vehicle for any items of value inside the vehicle.
When you conducted that inventory search, what happened?
I looked underneath the driver's seat, and that's where I found there was a green and a silver, like a pill bottle or like a tube. There was no markings on it. It was just a solid color. And that's where I found multiple bottle folds of suspected heroin. And I found multiple small ziplocs of crack cocaine.
Turning first to the lotto folds of suspected heroin, why did you suspect that that was heroin?
From past experiences, a lot of people pack heroin inside of lotto folds and fold them up to sell them.
What was the substance that you saw inside those?
Inside of the lotto folds?
Please describe that substance.
It looked identical to heroin.
And regarding the, what you said, suspected crack cocaine, why did you suspect that?
There were rock forms inside of a clear, small Ziploc bag.
Do you recall approximately how many bags of each suspected substance you found?
I have to refer back to my report to be able to specify that.
Would a copy of your report refresh your memory?
Yes.
Showing opposing counsel. Commissioner Prochar?
Yeah.
Also, take a look at this material and look up when you're finished. Officer Stokes, do you remember?
Yes, ma'am.
I'm gonna ask my question again. How many bags of those suspected substances did you recover?
So it's going to be 33 small Ziplocs of crack cocaine, and I believe it was 12 of the long holes of heroin.
Now, Mr. Stokes, after you conducted an inventory search, what, if anything, did you do?
Could you specify?
At any point, did you have further contact with the defendant?
Yes.
What did that contact look like?
So I did my search incident to arrest, and that's where I found two separate clear knotted bags of Xanax and ecstasy.
And where did you recover those?
That was from the left pocket of the pants.
Of the defendant's pants? One moment, Your Honor. Now, what was in that knotted bag, officer?
That was, Xanax and suspected ecstasy.
When you say suspected ecstasy, why did you suspect that?
There was pills with no stampings on it, and they were different colors, and from past experience, I've had ecstasy pills in that form before.
The way that these suspected narcotics were packaged, what, if anything, did that indicate to you?
That they were ready for distribution.
One more, Your Honor. No further questions at this time.
Morning, officer. So, when you first initiated this traffic stop, you specified that it was because of lack of place and registration?
Yes, ma'am.
Okay. And as your duties as a police officer, does your chain of command essentially give out any law updates that come out?
Yes, ma'am.
Okay, so you get updated regarding any updates and changes in the law?
Yes, ma'am. Yes.
And isn't it true that at the time of this incident, the law regarding registration was actually modified to allow for a title to be effective from a sale, a personal sale from a non-dealer through March 31st of 2021?
I don't recall.
That's chance for a legal opinion?
I'm asking him that his knowledge of the law, Judge.
I'd be asking him for a legal opinion.
Okay. Were you aware that there was a modification from the legislature in December of 2020 regarding registration and other issues because of the closure of the Secretary of State?
Objection, Your Honor, relevance?
Your Honor, it's relevant because the basis of the stop.
Your Honor, I believe
Basis
this
of the
officer.
stop is no license plate, et cetera, so he's entitled to look into it. So even, that might go to a charge of having no license plate on the vehicle, but it doesn't stop the stop, and it doesn't affect the stop. He's still entitled to investigate, based on what he saw.
But additionally, Judge, it also goes to the inventory search and impounding of the vehicle.
So, we have a driver's license.
But the officer doesn't automatically have to impound a vehicle if the person does not have a driver's license. They can get another licensed driver.
He didn't have a driver, there was no one else there.
But
they're supposed to call out and say, call your family, get somebody down here, we'll sit out here for the next 8 hours and wait. No.
And
he was alone. Car was on a public street. They had a right to tow. He didn't have a driver's license. He couldn't drive away in the vehicle.
Judge, even though it was on a public street, it was legally parked and not.
Doesn't matter.
Okay, I'll move on, Judge.
Thank you.
But you did testify that Mr. King Thomas did present to you a valid title, correct?
Yes, ma'am.
Okay. And when you initially searched the vehicle, you testified that you found a silver plastic container,
Yes, ma'am.
and you actually had to use a knife to open that container, correct?
Yeah, the correct scene.
Okay. And it was just a small container, maybe about 3 or 4 inches in height, about 2 inches in diameter?
It was about the same size as the pill bottle.
Okay. And the other container, which was a green container that you found a lot of holes in, that was similar size, correct?
Correct.
And
item, in terms of the silver container, where did you locate that item?
Underneath the driver's seat.
And the second item, where was that located?
Underneath the driver's seat.
Okay. And when you first approached the vehicle, when you were first making contact with Mr. King Thomas, you actually asked him if you could search the vehicle, correct?
Yes, ma'am.
And he declined consent to search?
Yes, ma'am.
And he also tells you he just recently bought the vehicle, correct? Within 2 weeks prior?
I don't recall the time frame.
Okay, it was a short period before the stop, though, correct?
I don't recall.
And in your experience as an officer, it's also usual for just users of drugs to have drug items packaged in baggies or bottles, correct?
Objection, relevance?
Well, then you ask about his opinion as to what the drugs were for. It's the same as right. You ask the question.
Can you restate the question?
Yes. So you've been an officer for almost 3 years now, right?
2 years.
2 years, I'm sorry. And you've done numerous traffic stops with narcotics, correct?
Correct.
And isn't it true that if someone is using a narcotic for personal use, that packaging can also still be in a plastic baggie, correct?
No. From personal experience, for users specifically, it's usually a small amount in a small baggie from what I've experienced.
Okay. So then, yeah, so,
Not multiple.
okay. So you've never seen a personal user have more than 1 or 2 baggies? So in terms of, you testified there were 33 small Ziploc bags of alleged crack cocaine. In each individual plastic baggie, do you have an estimate as to how much the actual amount of cocaine was in there?
No.
Okay. And in terms of the individual bottlefuls, you testified there was 12 bottlefuls. Do you have an estimate in terms of what the individual amount of that?
No.
Okay, just a moment, Judge. You were in, did you run the vehicle to see who the prior owner of the vehicle was next to you?
I do not run the vehicle.
Okay. And you don't have any recollection in terms of who the owner was that came back?
No.
Nothing further, Judge.
No further questions for this witness, Madam. No further witnesses to the people here. But we do have that.
No. Go ahead.
I'm assuming no, defense witnesses.
No, Your Honor.
Your Honor, at this time, pursuant to MCL 76611B, the people are moving to have admitted a preliminary analysis on narcotics that were conducted that was done on January 12th of 2021 by Officer Johnson. During that time, certain articles were submitted. That would be a container with 12 small bags of the substance, another green container with 23 bags of a small substance in lotto folds, and then another one with 21 small Ziploc bags, as well as a knotted bag. During that time, the preliminary analysis
demonstrated that there were 3.3 grams of heroin, 2.9 grams of cocaine, and 1.7 grams of ecstasy. And, that all of this information was submitted under Loxio folder number N05744144, incident number 21-0111-030. Oh, sorry. I apologize, Your Honor.
N057.
Back to the Loxio folder number N05744144, incident number 21-0111-0303. And that the person submitting that was Officer Stokes, and the defendant's name was Dante Kane Thomas. And the crime location was Harper Avenue and Holcomb Street.
Is that it?
That is it, Your Honor. This time, people move to have the defendant found over on all 3 charges. We heard from Officer Stokes today that the narcotics that I mentioned a few moments ago were recovered from the defendant's vehicle, a vehicle that
Well, where's your chain of command?
I'm sorry, Your Honor?
Where's your chain of command?
Your Honor, I did indicate that based on this preliminary analysis, that this
I
officer.
got that. The command deals with before that.
Understood with the recovery of the weapons and whether or not they were placed in a Loxio number. Is that
There's
correct,
no
Your Honor?
weapons, you mean the drugs.
I apologize, Your Honor. Yes, the drugs
Yes,
that
whether
were
or not they
recovered.
were placed on like a folder, we don't have that.
You're correct, Your Honor. I did not ask this witness if I would be granted the latitude to bring him up to ask him that procedural question.
The argument.
The people had ample opportunity to address all the elements of the necessary procedural requirements on direct examination, failed to do so, so I would object.
Right, well, we forgot to ask one question, whether or not it was placed on lock still folder. We never tied it all together, and we did the same thing. So I'm not going to look for, it's still going to follow. So, you can refine with it.
Thank you, Your Honor. At this time, people recall for purposes of proof, Officer Stokes.
Unless you're willing to step to the lock still folder number.
I would stipulate that that is the folder number that's listed on the preliminary laboratory sheet.
Not the stipulation I need. I need the stipulation that the officer that the drugs received were the ones taken from the vehicle, placed in lock still folder N057444144. You willing to stipulate to that, or you want to recall?
I would ask her to recall the witness by touch.
All right.
Your Honor, this time, recall Officer Stokes. Officer Stokes, please state your name for the record.
Officer Michael, MICHAEL, Stokes, STOKES.
Officer, I do believe you are still under oath at this time. Regarding the recovery that you testified to a few moments ago, did you do anything with those recovered suspected narcotics?
I transferred them to the narcotics unit.
You placed them under a Loxio folder number.
Yes, ma'am.
Do you recall that Loxio folder number?
I'd have to refer back to my report to be able to give you the number.
Closing counsel. Commissioner Brooks, Your Honor.
Ma'am.
Officer Stokes, is it on that first page of your report? Officer Stokes, is there another document that would refresh your recollection to the lock seal folder number?
I could, if I could look at my partner's, incident statement, it should be on there.
Permission to approach, Your Honor. Thank you, Your Honor. Officer Stokes, after you recover suspected narcotics, what's the procedure that you follow?
You call narcotics, you give them the circumstances of what you have, and they'll either tell you whether or not it's good or bad.
Do you fill out any paperwork at that time? In addition to your report?
So, are you just basing off of the, like, while I'm at the traffic stop or after?
When you have the narcotics and are passing them over, do you fill out any paperwork at that time?
Yes, I go to narcotics and fill out a lab sheet.
Did you in fact fill out a lab sheet for this case?
Yes, sir.
Would that lab sheet have the lock seal folder number?
Yes.
If I show you, or what a copy of the lab sheet for this particular case, refresh your memory as to that lock seal folder number.
Yes.
Officer Stokes, at this time, do you recall that lock seal folder number?
Yes, sir.
Please state for the record what that lock seal folder number is.
It's the Nora 057-44144.
Permission to approach again, Your Honor?
Yes.
No further questions, Your Honor.
Any cross?
Briefly, Judge. And Officer Stokes, when you initially recovered the narcotics that you found in the vehicle, is it true that you just threw the narcotics in your glove compartment? You placed the narcotics in your glove compartment of the vehicle?
I don't recall.
Okay. And what is the normal policy and procedure in terms of when you initially recover narcotics? What are you supposed to do? Where are you supposed to place them?
So when you recover narcotics, you call narcotics, you get the lock seal number from them, tell them what you have, and you're supposed to secure the narcotics in the vehicle.
Okay, and where in the vehicle are you supposed to secure them?
I don't recall.
Okay. And are you supposed to place them into an evidence bag initially?
We don't carry around evidence bags.
Okay. And so if your body camera revealed that you had placed some of the narcotics in your glove compartment, you would not use that?
Wherever I put the narcotics in the car at the time is where I put them.
Okay. And is there any policy that explicitly permits you to place recovered narcotics within your glove compartment?
Not that I don't recall.
Nothing further, Judge.
Anything further?
Officer Stokes, in your testimony today, that you remember putting the,
What difference does it make? How do you understand it's relevant? The policy is put it in the vehicle, secure it in the vehicle.
understood, Your Honor, then no further questions at this time.
Not wrong.
Nothing further at this time, Your Honor. I reserve all further arguments for rebuttal.
So that was just object back over for the record. I know the court wouldn't really let me get into it, but, my position is in terms of, the inventory search conducted by the officers was improper, pursuant to MGL 257, 252D. I don't believe that the officers have authority to inventory search the vehicle, and pursuant to policy, DPD policy, I believe that, it was an improper inventory search, so I would
There you go.
Brief rebuttal, Your Honor. I do believe the defense counsel is trying to get into the issue of the fact that there was no registration on the vehicle, and therefore the officers did not have cause to impound the vehicle. That is not correct. The defendant did not provide a license. At this point, there was no one else to take the car, and it was within officer's discretion on whether or not to try and find someone else to take the car or to impound the vehicle pursuant to an inventory search. At this time, all further issues are issues for of fact for trier fact, and I reserve all future arguments.
Court having heard the argument, and testimony finds as follows: that on January 11, 2021, the officer spoke to working special ops in uniform in the semi-marked vehicle near Holcomb and Harper, observed a white caddy with the license plate. Basically, did a traffic stop, asked about the plate, then he had just bought the vehicle, and he had title. He was asked to give his license, registration, and insurance. He gave a Michigan ID card and a title. That the driver was the defendant, and step out the car, going to tow the vehicle. He did an inventory search, found the narcotics, placed on lockstep Florida in 05744144 during the analysis of coherence between consistency. That, he followed procedure. He did what he was supposed to do. The defendant, there was no other person to turn the car over to. The defendant did not have a driver's license. If he had left the vehicle out on the street and it had been vandalized, then the defendant would be coming back after the city for having his car left out on the street and vandalized. So, no, he did what he was supposed to do. The court finds that the felonies enumerated in the complaint warrant did in fact occur to Detroit. Probable cause exists charges as it can be found over the Wayne County Circuit Court Criminal Division for further proceedings. Bringing on information will be May 4th at 9 o'clock.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Mr. Sullivan, how you doing? Good morning.
I'm doing fine. How are you doing? I apologize for being 3 minutes late.
All right, you're actually behind. Yeah, we got one, still got one in front of you. I don't know what's gonna happen. That's what's happening with that.
Okay.
Hello.
You ready?
One moment, Your Honor. I believe Mr. Lee has filed.
I have a question, if I may, Your Honor. I apologize.
Yes, sir.
I have a matter that's 100% about to be, KP is going to be issued because I have not had communication with my client in any shape, form, or fashion. And I have no reasonable explanation for his absence. So.
Okay.
Is Davis here?
No. He's not here.
Calling case number 2057298, the people of the state of Michigan versus Deon Davis. Defendant is charged with count 1, police officer fleeing third-degree vehicle code. Count 2, driving reckless. This matter is scheduled for examination. Defendant has failed to appear.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, 884724.
And good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles, on behalf of my client, that is Mr. Dion Davis, who is physically not present in the courtroom, nor is he present via Zoom.
All right. If you shall enter, any bond previously submitted shall be forfeit. New bond set, 30,000 cash. All right, thank you,
I appreciate your court, Your Honor. Thank you. To you and your staff, have a great day. Hey, Kitty.
Hey, Mr. Todd.
Have a nice day.
You too.
Okay. Okay.
Okay, fine.
That was a sneeze.
That was a call.
Oh.
Oh, I apologize, Your Honor.
Okay, I'll take the blessing. You conversate.
Ready on Adrian Kelly. Calling case number 2060996, the people of the state of Michigan versus Adrian Kelly. Defendant is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing, count 3, weapons owning firearm. This matter is scheduled for examination.
Good morning, Your Honor. Assistant Prosecutor Glenn Lee for the people. As Bob Harris, Mr. Kelly was present in the courtroom, judge ready to proceed. For the record, move to sequester witnesses. Judge, at this time, I have an officer charged Gregory Turville here. I do not have a special police officer witness to testify in this matter. We would therefore, just for the record, request an adjournment.
Well, I'd have to move to dismiss, Judge.
All right, that is dismissed.
I'm up there. I'm here.
Sure.
I had two cases, yeah.
You have a thing with there.
Oh, yeah.
You know, witnesses testifying today at trial at any time in the future will be in the courtroom or be denied that future testimony. That's the first step of all charge.
We are asking for that exception, Judge, and also joining in a motion for sequestration.
Any objection? There.
I thought the court just dismissed the case.
The officer just walked in the door and signed the order.
Oh, okay, well, I guess never mind about the order. I'm sorry, could you repeat that, Judge?
They asked for acceptance of officer in charge on the sequestration order.
No objection.
All right. You know, witnesses testify, all right, give acceptance of officer in charge.
People are calling Officer Turner up to the stand. Right. Good morning, sir. Your name for the record, please.
Officer Sequoia Turner.
And Officer Turner, what is an officer?
Yeah. TSS, Detroit Police.
Detroit Police? All right. And I'm gonna take you back, pardon me, to a date of, October 3, 2020. And a location of approximately Van Dyke and Quinn Street.
We were on duty police officer at that location at date about 8 o'clock or so that evening.
Yes,
Okay. Was that location in the city of Detroit County away?
yes.
All right. And then at that time, sir, who were you working with, if anybody else?
I was working with Officer Tyler Scott and, Rumsfeld.
Okay. For the record, are you SCHLAG? Okay, and how were you dressed at that daytime location?
In full uniform and fully marked governor.
Okay.
Judge, if I might, can I ask the witness to speak up a little? It's kind of hard to hear.
Yes, sir.
Okay. Other officers were dressed how?
Also in full uniform.
Okay. And the reason for you being at this location was what, sir?
I observed, the defendant, throwing some, paper onto the floor.
Well,
Onto the ground.
the purpose for you being there, what, is it generally what were you doing at the time?
I was patrolling
Okay. Were you in a scout car or on foot?
in a scout car.
All right. All the other officers with you?
Yeah.
Who's driving the car?
I can't recall if I can refer back to the report.
Approach it.
Yeah.
Handing you two 8.5 by 11s with text on it. Do you recognize those?
I do.
What are they?
It's my report.
Okay.
Confirmation.
Does that assist you with the answer? Refresh your recollection.
It does not refresh my recollection of who was driving, but it does refresh my recollection on my parking source at the time.
Now, you were at that location on, what did you say you were, the reason you were there?
I observed Mr. Kelly throw some items onto the ground
Okay, so when this happens, where are you now, when you see this incident happen?
inside the scout car,
How far were you from Mr. Kelly?
approximately Carlin.
Okay,
One more.
all right, and this is 8 o'clock PM or so. Can you tell us what, if you can recall the lighting conditions were?
They were low lighting.
Okay, and when you saw him do this, as you testified, where was this gentleman standing?
In front of the diner on the sidewalk.
Okay, and then the sidewalk is in between the diner and,
It was in front of the diner, between the street and the diner.
okay. Now, when you see this gentleman do this, what happened?
I had asked him if he could, I had told him that he had dropped his items,
You told him that he dropped items?
that he had dropped some stuff,
All right, are you speaking from your scout car or on foot?
from the scout car.
Okay, and when he did that, or rather, when you stated that, what happens then?
He did not pick up his, the things that he had dropped.
Did he say anything to you?
Yes.
What was that? Do you recall?
Can I refresh my memory?
Looking at your report, assist you?
Yes, sir.
Right?
He stated, I know.
Okay. All right. What happens then?
I had asked him to pick up the items.
And what was his response?
He had only picked up one item.
Okay. What happens then?
I asked him, when he picked up the item, I saw that, he had, what appeared to be a firearm sticking out of his right side pocket.
Okay. Can you describe what piece of clothing this right side pocket would be?
It was his, jean pants.
Okay. And you indicated you saw that item Can you tell us how much of the item you sell?
Just the grip, small grip, portion of the grip.
Okay. And when you see that, what happens now?
I asked him, was it a firearm?
And what did he say to you?
Yes.
Okay. What happens now? Are you still, just like that, are you still in that squad car?
No.
Okay. Tell the court at what time you got out of the squad car during your encounter with this gentleman.
Sometime after he did not pick up the second item, and after he had confirmed that the item in his pocket was a firearm.
Okay. So how close were you to him when you saw that firearm in his right pants jeans pocket?
Again, approximately a car length away from him.
Okay. And, okay, so what happens after that?
I asked him if he had a CPO.
And did he respond to that?
Yes.
What was his response?
He said he do have a CPO and that it's in his truck.
And I'm sorry, I didn't hear the door closed.
He did have a CPO and it's in his vehicle.
Okay. Sorry. What happens next?
Because he did not have a CPO, I recovered a firearm from him until he can provide a valid CPO. He did not provide a valid CPO, and we began to detain him for further investigation, and he began to struggle with us pulling away.
Okay, hang on just a moment. I'm gonna go back a little bit now, all right? He indicated he had a CPO in his car.
Yes.
Was he given the opportunity to retrieve it?
Yes.
Did he walk back to his car?
Yeah.
All right. And how much time, if you can't tell us, do you get out and look inside of the vehicle for it? How much time did it take? Let me put it that way.
He didn't actually look inside his car.
Did he ever open the car door or window to his vehicle?
Yes.
Okay. And, did you walk with him?
Yes.
So following that now, was a CPL presented?
No.
All right. What happened now?
We attempted to detain him in handcuffs, and he began to pull his arms free from us and pushing us away.
Okay, did you tell him why you were going to detain him?
Yes.
All right, and what did you tell him?
We told him that we were detaining him because he don't have a CPO.
Okay.
Or he didn't provide a CPO correction.
Okay. All right, so now you are attempting to detain this gentleman?
Yes.
Okay, and what did you do to detain this person?
We attempted to detain him by putting his hands behind his back and trying to put handcuffs on him.
Okay, was there some other officer assisting you?
Yes,
Who was
both
that?
my partners.
I'm sorry?
Both of my partners.
Okay, your partner's names again, to correct the record?
Officer Elaine and the correct director, it was Officer Patterson, not Officer Rumsfeld.
Okay. All right, now, the person that you're trying to detain is that weapon. Is that person somewhere in this courtroom?
Yes.
Can you tell us where that person is in the courtroom, what that person is wearing today?
He's on the first bench and he's wearing gray with face mask along with dread.
For the record, identify Mr. Adrian Joseph Kelly. Okay. Now, and you're trying to detain this gentleman, what happens?
We continue to put his hands under pressure, I put his hands behind his back, and he continued to pull away, and we eventually come to the ground.
At some point in time, was he told what you were trying to do?
Yes.
All right, was he given commands?
Yes.
What were those commands?
To stop fighting us, and to put his hands behind his back.
Did he respond?
No.
Let me finish the question. Did he respond favorably to your question?
No.
All right. So then what did he do after that? After your command? What did he do after that?
He continued on pulling away from us, pushing us off and trying to gain his, to stand.
Okay. What happens now?
I took out my department taser and advised him to put his hands behind his back again.
Did he do so?
No, he said he would though. And
He said he would?
Yes.
All right, what happens now?
He did not. When I tried to put him back in cuffs or put him in cuffs, he again went back to struggling.
Okay. And then what happened?
Other officers arrived and we were able to forcibly put his hands behind his back and handcuff him.
These are other officers, not your partners?
Not my partners.
All right, okay. And I'm gonna go back on that. The weapon that, was a weapon recovered from him?
It was.
Can you tell us what it is?
Can I refer back to my report or what kind?
Would that refresh your recollection?
Yes, sir. I'm refreshed.
Okay, can you answer that question?
It says Smith & Wesson 380.
Okay. At some point in time, were you able to get cuffs on the building?
Yes, sir.
And when that happened, where did you go? Where did you place it?
Inside the scout car.
Okay. Were you injured at all during this?
No, sir.
All right. At any point in time, when the CPL presented to you during this occurrence?
No, sir.
All right. And getting back to the initial inquiry or encounter, why did what you dropped on the ground indicate anything to you? What's the significance of that?
He was littering.
Is that a ticketable offense in Detroit?
It is, sir.
All right. Nothing further.
Good morning, Officer Turner.
Good morning, sir.
Can you hear me okay?
Yes, sir.
I'm gonna try to. Judge, may I remove my mask to cross-examine?
No.
Oh, all right. You were on patrol with an officer by the name of Aline, Alelyne.
That's correct.
Okay, routine patrol, correct? And you happened to see the gentleman who you identified this morning, or was he standing on the street corner or what?
It was near a corner.
A what corner?
It was near a corner,
Okay.
yes.
All right. And you say you happened to see him drop some items on the ground?
That's correct.
And that was what, a bottle cap or some kind of wrapper or something like that?
That's correct.
Okay. And then you were the passenger side?
I believe, I'm
All
sorry,
right.
I can't recall exactly where I was at.
So okay, well, you were in the car though, right?
Yes, sir.
Your marked police car?
Yes, sir.
Okay. And at some point in time, you asked the gentleman to pick up what he had dropped, correct?
Correct.
What, did you just roll down the window, basically?
Yes, sir.
All right. And he declined to do that, that's what you're saying?
He only picked up one of the items.
Which one?
It was the bottom cap.
All right. So at that point in time, are you saying that you saw, oh, excuse me. Do I understand your testimony correctly that you saw part of the gun sticking out of his pocket?
Yes, sir.
Is that in your report, sir?
Can I refresh my memory?
Sure, absolutely.
I'm refreshed.
Well, is it in your report?
No, sir.
Why not?
Didn't put it in here.
Okay. But you asked the gentleman if he had a gun?
Yes, sir.
And he responded yes.
Yes, sir.
So at that point in time, then you ask him whether he had a CPL, right?
That's correct.
He says something to the effect that's in my car, correct?
Yes, sir.
Okay. Is that the point? You removed the gun out of his pocket, correct?
Yes, sir.
Okay. Was that the point that you removed the gun when You said the CPO's in my car or what?
Yes, sir.
Okay, so you removed the gun, you've got the gun in your possession?
Yes, sir.
Do you check in his car, or did somebody else check in his car?
I didn't check it.
All right, but so far as you know, he was unable to produce a CPO, correct?
That's correct.
Okay, so once you had the gun, then you're gonna put him under arrest, correct?
Detained.
Oh, okay, you went to cuff him, correct?
Yes, sir.
And then, after you had the gun, that's when he started resisting, correct?
That's correct.
Thank you, that's all. You indicated to the record as to when you recovered the gun. Was Mr. Kelly cooperative throughout that part?
When I recovered it. Firearm?
Up to the time you recovered the gun?
Yes, sir.
Thank you, nothing further. Nothing else, Judge.
All right, thank you, step down. Any further witnesses?
No, Judge. No witnesses.
Your Honor, for the record, both of my partners are both COVID.
Oh, I couldn't hear, I'm sorry.
Both of my partners are on COVID.
Oh, okay, we didn't need him anyway, thank you.
Right. Judge, at this time, we open the witnesses, we would make our motion to bind over count 1 and 2. My understanding is that with count 3, the felony firearm charge, the issue that I would have here basically is this, Judge, and this is something that, that don't know if I can bind over on that because he didn't necessarily have the weapon at the time, but I guess what we would argue the fact that it was in the same transaction. That's why we make the motion to bind over these counts.
Well, Judge, my response is this. Carrying concealed weapon, question of fact, resisting arrest, I suppose that's a question of fact. However, I would object to the felony firearm. The statute is very clear. I just looked at it this morning. Must be in possession of the firearm when the felony is committed. It's clear from the testimony of the officer that he cooperated at the time the gun was removed, and at the time he allegedly resisted arrest, based on the officer's testimony, he no longer had possession of the gun. So therefore, I would object to the bind over on felony firearm. I don't think the elements have been made that he was committing that felony of resisting while he had the gun.
Okay. All right. Court having heard the testimony argument finds as follows. And on October 3rd, 2020, approximately 8 o'clock p.m., here at Van Dyke, Quinn, Officer Turner was on patrol. He observed the defendant throwing or dropping some items to the ground. He was standing on the sidewalk in front of the diner. He told the defendant that he dropped the items. The defendant said, no. He asked the defendant to pick the items up. He took one item. As he bent down to pick up the item, he saw sticking out of his right pocket the grip of a handgun. He asked him, did he have a firearm? He said, yes. He asked him, did he have a CPO? He said, yes. He then recovered the firearm until the CPO was produced. He went to the vehicle, no CPO was produced. He went to detain the defendant. He struggled, put his arms free, and pushed him away. There was continued struggle, continued command for him to put his hands behind his back, and he refused. And other officers arrived, and he was had forcibly handcuffed them at that point. We're going to bind over on counts 1 and 2. Count 3, he did not have. He has to have the firearm during the commission of the felony. I agree. And as a result, I'm going to dismiss count 3 and we're going to bind over on count 1 and 2. Find out that those felonies did in fact occur in Detroit. Our cause is found over the Wayne County Court Criminal Division for arraignment on the information, which will be May 4th at 9 o'clock.
Thank you, Judge.
Thank you. I need a dismissal form for count 3, please.
Yeah. Okay. Craig, I'll see you. Take care.
I need another form. I already put it.
Just give it to count 3 only.
Okay. All right, I'm just waiting. All right. Sure.
Ready on Khalil King.
Yes.
Calling case number 2061014, the people of the state of Michigan versus Khalil King. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. With special warrant on behalf of P84724.
Good morning, Your Honor. For the record, Jeffrey Glazer, P46892, on behalf of Mr. King, who's here live judge behind me.
Mr. King, state your full name for the record, please.
Your Honor, at this time, the people have called out several times into the hallway. Our necessary officers are not here. They were properly subpoenaed and properly notified with reminders recently. I have no explanation for their lack of appearance today. They're not prepared to proceed.
Judge, we move to dismiss without prejudice.
Excuse me, matter is dismissed.
Thank you.
Need a dismissal form, please?
I will fill out, Judge, yes.
Okay, thank you.
I don't know, did he want to come? I heard him say.
I think it's worth for it.
Next one is 12. Sign it.
I just wanted to personally apologize. Not getting that last number was 100% my fault. It's careless and it caused more, it caused more time for your work. I don't want you to think that I don't take that seriously. I'm very sorry.
Well, I appreciate it. Right. You do very serious about what you do. You know, things like that. You know. So,
Well, I need to make sure that they don't happen. So, thank you for your time.
So when you get there, you don't know.
Yeah.
Okay. You emailed them, right, what did they tell you?
you want to step out, I don't know, down the hall, dress your ladies.
No, we don't have anything to do with it. They're the ones that, that they came and grabbed. They're the ones that make the decision. If there is something in the file, go away in the file. There's something there. You say you submitted something. All right. I don't know.
Ching, ching.
Okay, all right. There might be something, yeah, but they're supposed to email defense counsel. It's gun forward and you guys. Huh? Well, I guess is there an email for gun forward? Yeah, I would just do it that way. And, they'll, whoever's got the file, working on it, one of the prosecutors there will probably forward it to us. Okay. We don't, because we do this only, we don't have information about it.
Okay, thanks.
Okay.
Mr. Glass, did you want a copy?
Oh, please.
All right.
Client?
Yep.
Okay, thank you so much.
Are those orders up there for us, Kitty?
The pink?
Yep.
You're
Okay, I
always
gotta-
pink.
I gotta have, this more, and then someone can get those.
I don't know, did you want the copy of just the count 3 dismissed?
Yeah,
Okay.
count 3 filling, or, okay. Yeah, that would be the one dismissed.
What's our next one?
Black, waiting on attorney signing.
Mr. Black is out there?
She is.
Oh, it's a female?
Yep.
What's her name?
Eunice.
Huh?
Eunice.
Eunice.
Come on, Kenny.
I'm
How
gonna
old is she?
forget by the time I call it.
Eunice. How old is she? She's probably in her early 20s. Name like
With a
Eunice.
name like that?
Well, I can't tell. She got a mask on and got glasses, so if she's over here, I don't know.
Let me check her file.
I know. Eunice, thing, somebody named her after her grandma. So.
Right. Let's see what her.
We got caught up, it was looking bad for a minute.
93.
What?
Yeah, she kinda young, 93.
Oh, my goodness.
She's early 30s.
Yeah.
Early 30s.
I gotta keep checking because the officers out there, the big officer out there, they just having people sit down instead of bringing them to us. It depends on what officer is out there to do it. There's Mr. Simon.
Hello.
How you doing, sir? Let me get your information.
Yeah.
Oh, at the end.
Okay. 248-931-035. Yes, I did. So, well, no, I think they're.
Party's on black.
You ready? Actually. Don't worry about it. Okay.
You ready? Huh? Huh? Oh.
I know.
The first time.
Order of dismissal?
In the, middle at the bottom. The middle at the bottom.
Middle at the bottom, okay. I was- Okay.
Ready on Eunice Black. Calling case number 2061027. The people of the state of Michigan versus Eunice Black. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good afternoon, Your Honor. This is Prosecutor Blair with the people.
May it please the court, Jonathan Simon, P 35596. On behalf of Ms. Black, who stands to my rear and to my left.
And thank you for the name for the record, please.
Eunice Denise Black.
Thank you. Ready to proceed?
Judge, at this time, the people are not able to proceed. We do not have our officer here, Officer Hyde. Essential, yes, that is. We would be respectfully requesting.
Move to dismiss without prejudice.
Can I bring the call? Very good.
Yep.
Good afternoon, everyone.
Good afternoon.
Hi, Jessica.
Do you want some tacos?
Ooh, tacos.
Oh, I wish I could. Thank you. Appreciate it.
I do.
Kitty does. Want me to get her?
Oh, today is Tuesday, right?
Tuesday taco day.
Taco Tuesday.
How you want?
What kind?
How you want?
The chicken fried.
Chicken, what?
The chicken with the shell fried.
Chicken with the shell fries?
Want
She not
corn
gonna
or
come get my
flour?
money? Huh?
Want corn or flour?
Flour. It was
Flour.
flour fried.
Everything?
Yeah.
Okay.
Did she get the order at home? You want to get it?
Fried. She shake her head no.
Oh, okay.
What did you say? Is it chicken what?
It's chicken, well, you got two
It's a
shells.
chicken taco, but it's,
Corn.
yeah,
Oh, the shell's fried.
yeah.
Okay, I'll tell her. You want me to give her that 10 spot?
I tried. She said no.
She said no? Okay, good.
That's good.
Okay.
You're out there putting your knees up high and you're walking all the way and back, bringing them up.
I'm walking.
Making it count.
Walking, trying to get some of the stiffness out.
Yeah, that helps. We try to do that, put out there, if I have to walk, hold on. Bring them up and kind of pull all this back.
I'll say that for the night.
Still fun? You ready to say, you do that, and then you're gonna go somewhere and lay down.
So, what game last night?
This, Prince Edward, you play with him, Junior?
I have, but I don't know.
Oh, really? Wow.
No.
Does he, do something with you?
Yes. It's gonna be Miss Parker, she said.
Is there a victim advocate on that one?
Yeah, he's talking to them.
Bird?
Yeah,
Okay.
they're in the room right next door.
What do you play, 3-on-3? You can't right
No,
here
I
next
swear,
door.
next door,
Did they increase the, number of people or so, or the, going by rules, how does that go for social distancing?
yeah. Yeah, we don't, we have the team out there. You have to take a mask on, like yeah.
Here. Down on my face. Here you go, me, I do 3 or 4 masks. That's probably why, too.
Yep. Yeah.
Hey,
There you go.
Hey,
This, Mr. Moody's. He's the mix. I need some more envelopes.
Hey, Antel,
Oh.
Hey.
Can you hand me some, that box with the W on top?
You got some more of these for me tomorrow?
Dang, how many was it? Oh, yeah.
You need more? Need more?
A little bit more.
Okay.
No, that's everything. You did them all?
That's it, yeah.
Okay, so I can.
So I'm doing the mailing now.
Oh, can you take these down when you, because you're gonna take them to the mailroom, right?
Yeah.
Thank you.
Anything else?
Nope, I think that's it.
All the
Okay.
parties are here on the next case if y'all want to call.
Yeah. So,
It's a whole, it's
Oh, quick.
yeah, but she's
Johnny,
not
quick.
doing part.
He's not doing it?
No, part is just standing there for.
Oh, oh, shoot, I know what I have to add, yeah. Hey, Glenn, so this Kitty, and tell, he just left my courtroom, I think he's going back in there. If he goes in there, can you tell him to call me? Thank you.
What's the AOI dates we're given?
Huh?
AOI dates for like Kelly, what was
The
it?
Giles is 4/27.
Kelly's was not a jail.
Oh, no, 5/4, May 4.
Thanks.
Judge, these are, submits from the ones that you adjourned. And tell, is helping me, he did them for me. Is Reggie on Zoom, Judge?
Yeah, they're on all morning in the background.
Oh, okay. I think that he needs to ask you or talk to you. He said he needs to ask you or talk to you.
Reggie?
Judge, good afternoon.
Good afternoon.
Judge, I have an exam before you at 3 p.m. today with the defendant in custody at MDOC. He's admitted to be there in person. However, there's a couple of issues going on today. One, my witness is awaiting a COVID test. She was symptomatic as of yesterday. So I advised her not to come to the court because they wouldn't let her in. And I told her to appear by Zoom.
Okay.
The other thing is that my understanding that defense counsel had her own issues, and I advised her to appear via Zoom now to discuss it with you, but I haven't seen her yet or heard back from her. She indicated to me that she would not be appearing in person either.
Well, I figured she would because she had one a day or two ago, and there was an issue where she was quarantined. So I figured she wasn't gonna be there.
Okay, that was my understanding as well. Now, you still want me in person?
I mean, if everybody's be on Zoom, there's no reason that you can't be on Zoom too.
But I believe that they're going to
How many witnesses you got?
1, 2 at the most.
The other main appearing on Zoom.
I'm sorry?
The one main witness is appearing on Zoom.
That's correct, Your Honor. Now, I believe that they will be transporting the defendant to your court because I did advise that it was an in-person hearing, and that was on March 30th that I writted him out for today's date.
Yeah.
He's here. You talking
Who's
about
here?
Lewis?
Yes.
Yeah, he's here.
Okay. And I know that I did tell defense counsel that if she waived the exam, she'd most likely have go to Third Circuit and get time served for his offense. But she said she wanted a breakout room with him. However, he's in person. So I don't know how that's going to work.
Right.
Well. Unfortunately, the courtroom will let her talk to him. I ask you to step away from Zoom for a few minutes, let her talk to him. That's about the best we can do.
Okay. All right. I just wanted to bring it to your attention and let you know.
Okay.
All right. Thank you all. I'll see you in a couple hours.
All right.
Bye. Thank you.
Oh, I think we ready on blue. Ready? Yep.
Let me get this more.
You went looking for you. That was funny. You went out one door. Ready on Richard Honolulu, calling case number 2056732, the people of the state of Michigan versus Richard Honolulu. Defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do grave bodily harm, less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault. This matter is scheduled for examination.
Good afternoon, Your Honor. Elizabeth Moore on behalf of the people, P84724. And good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74267, appearing on behalf of Mr. Honolulu. I'm appearing, standing in for counsel record Cheryl Quick, who's on maternity leave, Your Honor. Mr. Honolulu, is present in the courtroom and standing behind me. Mr. Ronald, will you please state your name for the record?
Richard Ronald. Are you ready?
Yes, Your Honor. Please record here. All officers, I apologize. All witnesses are currently sequestered with the exception of the officer in charge, Jacob Schmidt, standing in the court. He will not be testifying today. Not for purposes of exam, Your Honor. I do have one thing, you know, for the record, Judge. We have not been provided electronic discovery in this case. We have the initial paper discovery, but there has been no body cams or electronic discovery under in this case. Your Honor, I do have something to note on that. For the evidence.com laws, we have the evidence was not only provided but successfully downloaded on April 16th.
Okay.
I'm happy to provide that link to Ms. Farkas herself so that she has it in court today. But I did confirm that that was successfully downloaded 4 days ago. Yes. April 16th is what I have in our records. I'm happy to double check.
Was it sent? Where was it sent?
Evidence.com.
What? I believe to, she's been off on maternity leave since last month.
And Your Honor, that was the attorney record last
That's
time.
what it's supposed to finish with. Yeah, the first was the attorney of record, that's what they were supposed to send it to. That's what they did. All right, you know, witnesses testifying today at trial in the hearing with the court will be denied that the testimony. In exception to the officer in charge, call your first witness.
Judge, would the court grant a short continuance in this case to allow me to be able to review the electronic video? I know Ms. Quick has an automatic reply on her email, and if it should have gotten bounced back to somebody to contact my office.
Your Honor, we do have a civilian witness here. He has been here. He arrived early, knowing that the court prefers timeliness. If Ms. Marcus believes she cannot adequately represent the defendant in this matter, we certainly don't want to interfere with justice, but we do believe that we have done everything that the people are expected to do regarding discovery in this matter.
And this is an assault with intent to murder.
Yes, Judge.
So you're saying that the event was on video?
No, there was a body
I don't
camera.
care about afterwards. I don't care about arrest afterwards. That's irrelevant for the most part.
There's the statements of the complainant that were caught on body cam in terms of him reporting what happened to the officers. There's the, I'm assuming officers at the scene of the house that would have been caught on their body camera video. The photographs that were provided to me are not of the best quality, so I was hoping to be able to actually review video.
Your Honor, defense counsel is correct, but we are only calling one person that's the complainant today, Marcel Marshall. Nothing of the actual assault that took place is on any of those cameras, only the officers' cameras once they arrived on scene after being dispatched.
There you go.
I'm sorry, Judge?
I'm ready to go.
And again, I'm concerned in terms of any potential ability to impeach or cross-examine him down the road without being able to fully review the discovery.
You need to cross-examine down the road, you're talking about if it's found over.
Yes, Judge.
You'll still be able to get the information and you'll still be able to cross-examine.
I'm saying if the witness isn't available for trial, people could always move to use the transcript from today's proceeding and without.
Well, then you'll have another issue.
Okay.
But, you know, technically, it's your office that gets the assignment. You know, the fact that Ms. Quick went on maternity leave and, you know, I'll do with that.
And Judge, I believe the last time Ms. Quick appeared on this case, when the state got scheduled, she informed the people that she would be on maternity leave on the state.
And I told her that she'd get somebody to cover. That I wasn't adjourning it because of that. But it's another thing. I gave her that date, and now we're here. I'm ready to go. You call you with.
Your Honor, at this time, people call Marcel Marshall.
First name. Amen. Marshall, 102.
You raise your right hand. You swear or affirm the truth, the whole truth, and nothing but the truth shall be done. Say yes? Yes. I have to hear you. Like, you pull the door right here. And Mr. Marshall, you're going to ask a series of questions. First by the prosecutor, then the attorney will try to answer some questions. And I may or may not answer. Right? You have to answer all your questions out loud verbally. Just need to shake your head or down. Everything can transpire. All right? Also, when you ask a question, you just answer that question and stop. If it's a yes or no type question, just a yes or no. If additional information is needed, just ask another question. Well, I know nothing about this case, or what I hear in court. We all have a tendency, when we're talking about extended sessions, that the event is traumatic, we can ramble. We'll say this happened, and this happened, and this happened, and this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision. Okay? I get all my information from what happens in court, one question, one answer at a time. That way I can understand. All right? So, last but not least, because of the mask and the barrier, please, keep your voice up so everybody can hear. You can actually pull that microphone down. You can talk directly into that, and it will help amplify your voice. All right, thank you.
Sir, please say, and, I apologize, sir, please restate and spell your name for the record.
Marcel Marshall, M-A-R-C-E-L, M-A-R-S-H-A.
I know the judge just spoke to you, but make sure to keep your voice nice and loud so that I can hear you, defense counsel, and the judge and the court reporter all hear you, okay, sir?
Yes.
Now, let me take you back to April 21st of 2020. Where were you on that day?
April 21st, 2020, I got a call from Richard.
When you say that you got a call from Richard, do you know Richard's last name?
Yeah,
Sir, I need you to speak up.
100.
Would you recognize Richard Honolulu if you saw him today?
Yes,
Do you in fact see him today?
yes.
Please point to him, identify where he is seated, and pick out an article of clothing that he is wearing.
He's seated right behind you. Right there. Suit on. Suit jacket. Tie.
Let the record reflect that the witness has identified the defendant, Richard Honolulu. Now, Mr. Marshall, are you familiar with the location of 1501 Seminole Street?
Yes, ma'am.
Is that in the city of Detroit, County of Wayne?
Yes.
What is that address? Mr. Marshall, if you can take just a moment, can you tell me what that address is?
I can't recall.
What is at that address?
house.
Okay. Were you at that location on April 21st of 2020?
Yes.
Who was at that house with you?
Me.
What were you doing on that day?
On that particular day, like I said, I called for the gym. I had an hour or so scared, kind of busy. Come over, have a couple drinks, go in there, chill.
Mr. Marshall, did you go over to the house?
Yes.
And when you were at the house, what if anything happened?
Well, I went to the house, and we proceeded to drink, talk, conversate, and there was a money exchange. He gets some change for some money.
Mr. Marshall, hold on. I want to make sure you're speaking up nice and clearly and not too fast.
There was a money exchange. He needed some change for some money. I changed the amount. Had another drink. He left out of the room we were in. Gone for maybe about 25, 30 minutes. He was gone for maybe like 25, 30 minutes.
At any point, did Mr. Honolulu come back into the room?
Yes.
What happened, if anything, when he came back into the room?
He came back into the room, and he told me, bro, where's my money? You got my money. And I'm like, bro, what are you talking about? We just exchanged it. I got my money, got in your pocket, took the money with you. You left out the room, you were gone for maybe about 25 minutes. And then you came back.
What, if anything, happened after the two of you exchanged words?
Right after that, he said, well, bro, you're not leaving until I get my money. I said, well, bro, I'm not trying to hear that. I ain't got time to argue with you. I'm not trying to go through this. I got my money, you should have yours. And,
What, if anything, did you do after you said that?
I stood up, I tried to step around him, proceed to the front door, and he stepped in my face and repeated, bro, you're not leaving until I get my money. And I told him, once again, bro, I have my money, you got yours.
What, if anything, happened after that?
Immediately after that, I tried to step around him again, sidestep, and he jumped on me.
When you say he jumped on you, what do you mean?
He went straight for my face, scratching and clawing.
What was he scratching and clawing you with? I'm sorry?
You can ask him what happened. You can't just facts that are not in evidence. You didn't say he was scratching and clawing with anything.
When you say scratching and clawing, what do you mean?
Well, he came at me directly. He used his fingers, his nails, to scar my face.
Did he make contact with your face?
Yes.
What happened after that?
After that, he fell to the floor. He was on top of me. I grabbed his hands, his wrists, to remove him from my face. We touched him a little bit. Then I got up, got touched him a little more. Fight progressed out of the room, down the hallway, closer and closer to the front door.
What, if anything, happened when you approached the front door?
Approached the front door, more touching, more fighting. I picked him up in the momentum of us moving forward. We failed through the door. The house had two doors. One door is immediate.
Make sure to speak up, sir.
The house has two doors. Indian village, on the second right there. So one plain glass, the secondary door, the third door. Went through the first glass door, through the one into a bush. That's fine. I picked him up and failed through the first glass door.
What, if anything, happened after you fell through that first glass door?
There was glass around me, from the glass, and
picked up some glass, came in with the glass.
I'm sorry, Mr. Marshall, who picked up some glass?
Richard,
And what happened with that glass?
he grabbed the glass, and proceeded to come at me, at my, face, my head, torso.
Now, about that piece of glass, please describe what that looked like.
No bigger than,
Did you say no bigger?
about the size of my arm.
And how was Mr. Honolulu holding that piece of glass? In which hand, sir?
Right.
And when you said he came at you, what do you mean by that?
Well, he had it in his mouth, right mouth, and proceeded to move forward, straight directly at thighs, torso, stomach, head, face, neck.
As he went to do that, did the piece of glass make contact with any of the parts of your body that you just mentioned?
Yes.
Which parts of your body did the glass make contact with?
My head, face, neck, torso, midsection, stomach, thighs.
Do you know how many cuts you had in total?
Less than 20, maybe like 17.
At the time that the defendant was making those cuts, was he saying anything to you?
Yes.
What was he saying?
You're not leaving. I'm keeping.
I couldn't hear what you said.
Please say your answer louder and more clearly, sir.
You're not leaving, I'm gonna kill you.
Approximately how many times did he say, "I'm gonna kill you"?
Two. Three. One.
At this time, what were you doing?
I was defending myself.
When you say you were defending yourself, what does that mean?
I was applying as far as fighting.
Did you have any glass in your hand?
No.
After the defendant made those cuts on your person, what if anything happened?
Can you repeat that?
Yeah, after the defendant made those cuts on your person, what if anything happened?
Well, I tried to reach for the doorknob, exit the house. I made that attempt 3 or 4 times.
At some point, were you able to exit the house?
Yes.
What happened when you exited the house?
Exited the house. I got outside. Exited the house. Got outside, and I immediately tried to get some type of assistance.
When you say assistance, what do you mean?
Well, anybody that I see, first car, he started, I saw him, trying to wave him down, get the attention, call 911, ambulance, stuff like that.
What did you do at that time while you waited?
I laid down.
Why did you lay down?
I was kind of tired, a little winded, and a little sore, and I needed to breathe.
When all of this took place, how were you feeling at that time?
Excuse my French, pretty fucked up.
Without repeating what you said, what do you mean by that? One moment, Your Honor. Mr. Marshall, did you receive any medical attention?
Yes.
What did that medical attention look like?
Few stitches, yesterday, bandages, gauze pads. I stayed in the hospital for maybe 24 hours.
Now, sir, when you say that you got stitches, where did you get stitches?
To my head.
Was that as a direct result of a cut that you received during this?
Yes.
One more moment, Your Honor. At some point, did officers arrive on scene?
Yes.
Were you able to indicate what house you had been in?
Yes.
At any point, did you communicate to the officers who, what had happened?
Yes.
Did you explain who you had had an altercation with?
Yes.
Who did you identify?
Which arm?
No further questions at this time, Your Honor.
Good afternoon, Mr. Marshall.
Yeah.
You testified, about you picking Mr. Honolulu up. And so, you actually, in fact, picked Mr. Honolulu up and he crashed into the glass door, correct?
Yes.
Okay. And you actually pushed him into the glass door, correct?
I was holding him.
Yeah, you physically had him picked up.
Yep.
And then pushed him into the glass door, correct?
Yeah. So as far as momentum goes, if I fail,
Okay, so your testimony is that you guys fell.
I did physically push him.
Okay. And approximately how tall are you?
6 foot.
Okay, and approximately how much did you weigh at the time?
225.
Okay. And it's fair to say Mr. Honolulu is very slim built, correct? So yeah, you say he's about 120, 130 pounds? And he is several inches shorter than you too, correct?
I can put 5'9", 5'11".
Okay. And so you both initially just started, you described as tussling, when he first confronts you, correct? And when you say you guys are tussling, can you describe what exactly is going on?
For the beginning, he grabbed my face, I grabbed his hands. After the facial scar, we rolled over, we got up, we proceeded to elbows, fists, and momentum. Fell over a couple items in the kitchen,
Okay,
couple chairs.
okay, so you guys are essentially engaging in like mutual combat,
Yes.
fighting, hitting each other back and forth. Okay. And you punched and struck Mr. Honolulu, correct?
That was after we fell through the plastic.
Okay, but you admit that you punched and struck him?
Yes.
Okay,
In defense to incapacitate him.
okay, but you punched him after you had pushed him through the door, correct?
After we fell through the glass door. was laceration.
Okay, and isn't it true that you actually put Mr. Honolulu in a chokehold?
No.
You're denying putting him in a chokehold? Okay. Did you ever physically put your hands or arms or around his neck area?
No.
But you do admit putting him in a bear hug?
Yes.
Okay. And when you put him in a bear hug, were you squeezing?
No.
Like he was fighting back to try to get loose, correct?
No.
So he just
When I applied the
put
bear
there with
hug,
dead weight?
when I applied the bear hug, I had his arms incapacitated, so he couldn't use them.
Okay. Was he kicking at all?
No.
Did he say anything? Did he ask you to put him down?
No.
Okay. And then you fell through the glass door?
Yes.
Okay. And did you make statements that you were gonna kill Mr. Honolulu?
No.
So you testified that you got a few stitches on your head. Can you describe where on your head that you got those stitches?
Left side of my head, right where the hairline.
Okay, so left front, like forehead area at your hairline?
Yes.
And how many stitches did you get? Do you remember?
5, 7.
Okay. And that's the only part of your body where you got stitches, correct?
Yes.
And isn't it true that at the time of this incident, you were on parole for a assault, correct? Objection, Your Honor, relevance?
Yeah, well, I'm gonna strike it, it's improper.
Judge, it goes to his
It's
potential.
improper. You can only ask him if he's been convicted of a felony or misdemeanor involving theft, dishonesty, or truthfulness. Assault is not included in that. So it's stricken.
Okay, and you testified, that you were defending yourself and doing defensive moves. Did you get any cuts on your hands or your arms?
My hands, no. My arms, yes.
Okay, can you describe where on your arms?
Forearm, back of the arm, left arm, back of my arm.
Okay. If I could have a moment, Judge. Just to clarify, so when you and Mr. Honolulu first got into the physical art altercation, what room in the house were you in?
Kitchen.
Okay, and then, when you had picked Mr. Honolulu up, you said that's when you guys went down the hallway and towards the front door?
Yes.
Okay, and so, approximately how long in time total would you say that the incident happened between you and Mr. Honolulu, when you first, the altercation first started to when you actually got outside? Saying this is seconds, minutes, longer,
Minutes. 10 minutes.
10 minutes. Okay.
Maybe.
Nothing further, Judge.
Mr. Marshall, if you know, approximately how many cuts did you have on your head?
The main one that I had to switch up.
Do you have any other marks on your head or face from this incident?
Yes, probably. Top of my head.
What was on the top of your head?
Cuts.
No further questions, Your Honor.
Nothing further, Judge.
Thank you, step down. You step down, thank you.
Your Honor, people call no additional witnesses.
Ken?
No witnesses, Judge.
Motion.
Your Honor, at this time, people move to have the defendant bound over on all three charges. Today we heard testimony from the complainant, whose name is Marshall. He stated that he was at the defendant's address at this time. After being there for a while in a civil manner, the defendant left the room for several minutes, and when he came back, he was demanding money. That he told the defendant, "You can't leave." That a tussle, as the complainant stated, ensued, and that during that time, the complainant was trying to leave, that he made 3 to 4 attempts to try and get out of the house, but the defendant kept telling him that he couldn't leave, and even stated, "I'm gonna kill you," at least 2 times. That after the 2 of them went through a glass door, that the defendant grabbed a piece of glass, the complainant stated was at least the size of his palm, at least the size of his palm, and that when he had it in his right hand, he started to cut the complainant in several different locations. The complainant stated that he received cuts to his face, eye, head, neck, torso, thighs, and arms, both his forearm and the front of his arm. That he estimated he received about 17 different cuts at that time, and that that time was congruent with the defendant saying, "I'm gonna kill you," at least 2 times. The complainant stated that he was, again, trying to leave the residence, that the force that he used was more defensive force, and he was trying to leave the residence. As soon as he left the residence, he tried to contact help and laid down on the ground. He did receive medical attention that gave to his head. He spent about 24 hours in the hospital and had to bandage up the different areas along his body. I understand that the defendant has been charged with assault with intent to murder, and it is a specific intent crime that ultimately comes down to the defendant's intent at that moment. That we need to show an assault occurred, that the defendant had an actual intent to kill, and that if that had been successful, it would have made him guilty of murder. At that time, at least for probable cause standard, if not higher, that has been shown. The defendant kept saying, I'm gonna kill you, made several cuts with sharp glass that did in fact cut the complainant. I believe that any further issue is an issue of fact, for a trial of fact, it should be dealt with at the circuit court level.
We are in the alternative, correct?
Yes, the counts 2 and 3 are charged, or lesser included charges, charged in the alternative.
Any argument?
And Judge, I would object for the record, and do understand that, essentially there is a defense of self-defense with a mutual combatant situation, but it's an issue of fact, so I would object for the record. No rebuttal, Your Honor.
All right, go ahead and heard the testimony, I was trying to follow, and the 21st, 2020. That, the witness, Mr. Marshall, went to 1501 Seminole Street. We met with the defendant. There was just a talk, drink, chill. Defendant said he needed some change, they gave him change, he left out the room, came back, asked him where his money was. Tony wasn't leaving until he got his money. Marcus tried to leave, got in front of him, tried to flip Ronald, and then jumped him, scratching, even shooting him, scratched his face. Fight progressed all the way to the front door, and the witness had picked him up in a bear hug, and they fell through the glass door. Then picked up the glass, came at him. That was about the size of his palm. Somewhere around 3 inches, 4 inches. Then he hasn't made contact with glass in his head, face, neck, torso, eyes, and arms. He has 17 cuts. He did make a statement saying at least 3 times that you're not leaving, I'm going to kill you. He tried to exit the house. He eventually did get out the house. He was exhausted, angry, disappointed. He said he had stitches. The only place he had stitches on was his head. He did have bandages. He stayed in the hospital for 24 hours. I understand the statement that he made, and that might go towards his intent, but I mean, I can't see it here. I don't see an assault with intent to murder. I do see an assault with intent to great bodily harm. I'm going to bind him over on count 2 and count 3. I'm dismissing count 1. Court finds that those felonies did in fact occur in City of Detroit. Probable cause against the charge of suspended. We found over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 4th at 9 o'clock.
Thank you, Your Honor. Thank you, Judge.
Thank you. We have, Harris here for the last one.
Yeah, I believe. I know Mr. Harris called me earlier and said he was on his way.
He's not here?
But he should be here.
Is Mr. Harris here?
Yes, he is.
Oh, yeah, I mean, it was a lot earlier. You gonna, Counselor, you gonna do a dismissal for count 1?
Oh, sorry.
Just, check everything in the bottom, put, just this one on.
Michael Black.
I'll go out in the hall as well.
Good afternoon, everybody. How's everybody doing?
How you doing?
All right. Just want to give me this file, what you gonna do with it.
Yeah.
And tell say him.
He just gonna leave. Huh?
He just told me to hand it to you.
He said he didn't think he needed them to affiliate.
I'm glad he didn't, that's why I called him. Glad.
Okay. Okay, we're good. You don't need none anymore, I guess.
You ready? Ready?
No.
Oh. Ready on Michael Lackey? Calling case number 2062747, the people of the state of Michigan versus Michael Lackey. Defendant is charged with count 1, home invasion first degree, count 2, assault or assault and battery. This matter is scheduled for examination.
Good afternoon, Your Honor. This is the prosecutor, Glenn Williams, for the people.
Good afternoon, Your Honor. White here. Case 54891, retained counsel on behalf of Mr. Lackey, who stands to my left.
Lackey, state your full name for the record, please.
Michael Craig Lackey.
Okay.
Your Honor, today is the date and time set for preliminary examination. I've explained to Mr. Lackey his rights to an examination. He understands those rights, however, he wishes to waive those rights. We've gotten permission from the prosecutor to do so.
Judge, just for the record, our complaint with Mr. Michelle Elder, he's here. We do not, his brother counsel indicated objection.
All right, Lackey, you understand that you have a statutory right to preliminary exam where the state must show by probable cause the crime was committed and probable cause he had something to do with committing it. You understand that, sir?
Yes.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
Well, Your Honor.
You waive your right freely and voluntarily after having an opportunity to talk to your attorney about it.
Yeah.
Can you sign the waiver of examination form?
Yes.
All right, court of you freely and voluntarily waive your right to preliminary exam as filed over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 4th, 9 o'clock.
Thank you very much. I'll be out there in a second.
All right, Mr. Harris, so it's a pleasure.
Okay, buddy. We'll see you.
Yeah.
Judge, may I approach on a separate matter?
Yes, sir.
Good to have you.
Huh? Oh,